She can't see you.
Morning, Miss Ona.
Can't see you.
Good morning, sweetheart. How are you doing?
Good.
Get your hand on your face.
County, Texas. Court is broadcasting from Kendall County via Zoom and YouTube. Are there any objections?
No, Your Honor. No, sir.
No, Your Honor.
With that, then, Ms. Rush, would you please begin the announcements?
Personal action, Ona Powell for the department, ready.
Deborah Fuller, attorney for the mother. Ms. Grissom, could you please unmute and announce we're ready, Your Honor?
Yes, this is Sharon Grissom, Lane's mom.
Richard Sullivan, attorney for the child, ready, Judge. And I believe Lane's somewhere around there.
Lane.
Morning, Lane.
Morning.
Christy Cannot, permanency supervisor for Belong.
All right, Ms. Powell, we'll go ahead and start with your report here. Lane at this time is 15. When your report was filed, he was placed in Dallas County, Arkansas. Is that still his current placement?
No, Your Honor. He's been returned home.
Okay. And I gathered that from his presence there with his mother, but I just wanted to get it on the record. At this point in time, is his placement home with his mother safe and appropriate and meeting his needs?
Yes, it is.
What date was he placed there?
On the 2nd of July.
And have you been there with him in the placement and observed his interactions with his mother?
Yes, I did upon returning him, yes.
Okay. How have things been going? It's been a week. How have things gone for that week?
I haven't heard anything bad. Nothing negative.
All right. He's current on his medical and dental and vision, correct?
Correct.
All right. And he's up to date on his, well, actually strike that. I see he had treatment for cavities. All that's taken care of?
Yes.
Okay. Now that he's back in Texas, what's the plan for therapy?
For therapy, I have referred him to the Pursuit of Happiness. They will come out to the home to provide those therapy services to Lane. And they were accepted and approved for Chosen, which would help Ms. Grissom and Lane with incorporating him back into the home with some parenting skills.
Okay. And you believe that that'll be appropriate?
Yes, sir.
What county does his mother live in?
I believe she is now in, I'm not sure if it's Medina or Bexar County. It's right there on the line.
It's Medina County. The city.
Ms. Grissom, Ms. Grissom, don't speak until
Oh, I'm sorry.
Ms. Powell's answering questions.
He's on 3 psychotropics, and the review dates on these are from March, but do you know if they've been reviewed since then?
I don't know. When I received his medical records, it wasn't very clear. When the last review solid date that I could find was March, when they initially put him on the Depakote, and they went back and removed him from some of the other psychotropics that he was on. But that's the information I could find in the 120-page medical report they sent back.
Okay. How are his behaviors right now?
Greatly improved.
And what's the plan for school?
I believe Ms. Grissom is still working out the details. He may be homeschooled at this time. I believe she's still trying to settle on whether or not she'll put him back into the school system, since he seems to do much better in a smaller setting.
Okay. What's the status with his deferred adjudication?
He's been ordered to pay restitution. So they didn't drop the charges in Dallas County. I believe Harris County will be dismissing their case with him, but Dallas County they decided to keep it, and he's been ordered to pay restitution, I believe, of $500.
Okay. Any other issues with Lane at this time that we need to go over? Any other court orders needed as far as Lane is concerned?
No, not at this time.
Okay. And your report reflects that Ms. Grissom is in compliance?
Yes, sir.
Is there anything specific at this point in time that you believe she needs to do, considering Lane's just been placed with her?
Really just go along with Chosen, to work with Chosen and the therapist that'll be coming out. I think that would be best for her and Lane.
Okay. And do you believe that Ms. Grissom has all the necessary referrals and information she needs in order to continue to work her service plan?
Yes, she does.
At this time, do you think it's appropriate to keep this case open to continue to work with this family?
I think the case can be dismissed.
Ms. Rush, do you have questions for Ms. Powell?
No, sir. Thank you.
Ms. Fuller?
Ms. Powell, we had a meeting in regards to information that's been provided to the court and to other providers that has been inaccurate, correct?
Correct.
And the department was willing to write a memo and do an addendum to fix these errors.
Yes, ma'am.
And have you filed that with the court so the court can be made aware of the mistakes that have been done?
It can be filed today, but it has been uploaded into Impact on our system as of yesterday evening.
Okay. And since it hasn't been filed, Your Honor, I would ask that she have read it into the record since you haven't seen it, because there was a number of concerns throughout this case, and I want it read into the record if there's no objection.
No objection.
No objection, Your Honor.
So Ms. Powell, could you read it into the record?
Yes, ma'am. Okay, contrary to any previous reports, Lane has not been removed from his mother, Sharon Grissom, due to neglect or school truancy. In fact, Lane has never been in the custody of caseworker Ona Powell, nor has he been under the care of CPS since the age of 2. Lane's living situation has been stable and consistent for most of his life. He has lived with Sharon Grissom since the age of 2, and Ms. Grissom later formally adopted him. This adoption solidified the familiar bond and provided Lane with a permanent, loving home. Lane's adoptive father unfortunately passed away, but during his lifetime, he contributed to Lane's upbringing and care. It is important to note that Lane has no contact with his biological parents. Information about his biological mother's prenatal care remains unknown. Throughout his life, Lane has not been removed from his home by CPS. He has consistently been under the care and guidance of Sharon Grissom, who has provided a stable, nurturing environment. Ms. Grissom's dedication to Lane's well-being is further exemplified by her joint managing conservatorship with the Department of Family and Protective Services. This arrangement is specifically in place to facilitate Lane's access to mental and behavioral health treatments that are necessary for his development and well-being. There is no history of neglect or abuse in Lane's home. Sharon Grissom has ensured a supportive and caring environment for Lane, which is critical for his ongoing growth and success. The stability and care provided by Sharon Grissom has been instrumental in Lane's life, and any institutions to the contrary are unfounded. Any insinuations to the contrary are unfounded. This clarification aims to set the record straight regarding Lane's custody history and living conditions, highlighting the positive and supportive environment provided by Sharon Grissom.
Thank you, Ms. Powell.
You're welcome.
And in regards to this case, you're asking that it be dismissed, correct?
Yes, ma'am.
And so Ms. Grissom was already a joint managing conservator with the department?
Yes, ma'am.
And for the record, the court orders, previous court orders of the developmental specialists and the neuropsych, they've never been done. They've never been completed, neither one of them.
I was unable to find a developmental specialist.
And the neuropsych wasn't done. It was actually a psychological evaluation, correct?
Once we got down to it, yes, ma'am.
And so just for the record, this case really has been mishandled from the beginning. No court orders were followed. No consequences for those court orders has been done for belong. But now we're asking, and we feel confident that Ms. Grissom can take care of her son.
Yes, ma'am.
And I would ask that you file this in the record and make sure it's in the record with CPS as well.
Yes, ma'am.
And do you feel that Ms. Grissom is able to take care of her son's needs at this point?
Yes, ma'am.
And are there any other documents that need to be corrected besides the psychological evaluation? Have all the plans of service been corrected that had the misinformation? Have those all been corrected?
Yes, ma'am.
And any other documentation and impact, has it been corrected to show that this is a joint managing conservatorship case and that there was no abuse by Ms. Grissom?
Yes, ma'am.
And is it also in the record in impact now that this child was never removed by CPS and placed with Ms. Grissom, that she did a private adoption of this child after termination of the parents' rights?
Those records would have been entered in the FBSS stage.
Have you ensured that the records are accurate in your stage?
Yes, ma'am.
Pass the witness, Your Honor.
Mr. Saldivar?
Yes. Do you believe Ms. Grissom has the tools moving forward to meet Lane's needs?
Yes, sir.
Do you believe that therapy will be available to Lane going forward?
Yes, sir.
And do you believe that family therapy will continue after this case?
I can consult with Pursuit of Happiness to see if they can add that component.
Okay, just so that it's available for the family. Do you
Yes.
believe that's in their best interest to have that available?
Yes, sir.
Okay, and do you believe that since this case has started, you've seen a change in Lane's behaviors and how he handles situations?
Yes, sir.
Okay, and any concerns at this time for him being placed in his mother's home?
No concerns at this time.
Okay, and is this what Lane wants out of this case?
Yes.
And it's a matter of fact that he's been asking to return home for quite a while. Is that correct?
Yes, he has.
Okay, and since he's been placed there, we've had no major concerns. Is that correct?
No major concerns.
Okay, pass the witness, Judge.
Any other questions from any of the other attorneys?
Yes, sir, if I may it please the court. Ms. Powell, I'm new to this. I want to make sure I understand. Ms. Fuller asked you about things you didn't have done pursuant to prior court orders, like a neurological exam, something like that. Is that correct?
Correct.
Okay, you said you weren't able to find. I don't know what that means. Can you tell me what that means?
Throughout the case, I searched for a developmental specialist for Lane, but given his age, any of the specialists that I contacted, they were not willing to take him on as a case because they said he was too old. He was over the age of 12.
Okay, but prior to being placed with Ms. Grissom, he was in an RTC, is that correct?
He was in yes, Mill Creek.
And at the RTC, was he given counseling, psychiatric help, medications, individual plans to help him work with his behavioral issues?
Yes, ma'am.
Pass the witness.
Any other questions?
Just one follow-up in regards to the Social Security, the death benefits. Will those be all transferred back to Ms. Grissom? Has that been done?
To the best of my knowledge, she was getting a portion of the check once the letter was written and it was turned into the Social Security Administration. She now has the placement paperwork necessary to show that he is back home with her so that he can get any benefits reinstated.
Okay. Wasn't that an issue before that they needed something from CPS?
And it was provided.
Okay, so won't they need something from CPS or Belong to make sure she gets all of the benefits back?
If they don't accept the placement paperwork, I can write another letter. That wouldn't be a problem.
And there still was the issue of there's 5 months of payments that have disappeared somewhere. Have you been able to locate those payments?
That is out of my purview. I don't have any control over that.
Well, CPS is the one that had the payments transferred to them or Belong. So why wouldn't you be able to determine where they're at?
Because that's dealing with state office.
And
I don't have access to that. No, I do not. I don't have access to that information.
No further questions, John, but I do have a statement at the end of this.
Well, I want to see the attorneys in the breakout room briefly, please.
Yes, sir.
All right, looks like we have everybody back now. All right, Ms. Fuller, you wanted to make a statement. I'm going to go ahead and let you do that now.
Your Honor, I just wanted to, I'm sure the court's aware of my opinion of how this case was handled. And I want to apologize to Ms. Grissom for the way it was handled, because she shouldn't have been treated the way that she was treated. That's not what CPS is about. It's supposed to be helping families. She asked for help for her son and didn't get it. She was treated like she was a criminal at times. She was demeaned. The reports reflected information that wasn't accurate about her. And I want to apologize, to her for the way she was treated. I've been doing these cases for 30 years, and I've never seen someone treated like this, especially on a JMC case. I'm glad that the information was read into the record, but I would hope that Belong takes something from this case and understands that court orders need to be followed. Information needs to be accurate. These reports, this information follows this family forever. And if the child ends up back in care, or if other children end up back in care, then this information is in there. And when it's not accurate, it destroys any credibility for our system. And so I'm glad that Lane's home. I'm glad that he's doing well, and I hope he continues to do well. And I know Ms. Grissom will use the resources that she's been given, and she really learned a lot with Ms. Boone, and helping her, and she enjoyed those therapy sessions with Patricia Boone. And I just want to apologize for the way she was treated. I think it was despicable, and it's hard for me to accept that a family could be treated like that.
Ms. Fuller, Mr. Saldivar, anything else you want to add on the record?
Judge, just that this is what Lane wants. He wanted to return home. I believe Ms. Grissom has the tools that she needs to move forward to meet Lane's needs. I think that the therapy and the family therapy will be available to her. I've seen a change in Lane's behavior, and so has Mom. He's made better decisions, and so this small period of time that he's been home has been great. And so I just encourage Ms. Grissom to use the tools of therapy and medication review to make sure that Lane's needs are being met. And I agree with Ms. Fuller that we can get those documents changed, because this was a JMC case, and if we can make sure that we track down that money so that the family can benefit from those payments that were missed.
All right. Thank you. Okay, the first thing I'm going to do is these documents that are in question and the statement that Ms. Powell read, I want those sent to me, to my coordinator. Anything that you want me to see, Ms. Fuller, send it to Ms. Greenlee. Ms. Powell, send that statement to Ms. Greenlee, because I want to look into this. I want to figure out where things went, because I want to know how we can prevent this in the future. I want it to be a learning experience. I'm going to order that the department look into those missing payments. Ms. Rush and I've already discussed it. She's going to look into it. Those who are involved in this case are aware that I had previously made some contempt findings, and then it was brought to my attention that there might have been a procedural issue. So I abated those contempt findings, and when the parties requested an extension in this case, I granted it with the intention of moving forward with the contempt findings, following the procedure appropriately. I had a conference with the attorneys just now, and the consensus is that Ms. Grissom and Lane have been through enough, and that this case needs to be over. And I agree with that. But I also agree that mistakes made in this case don't need to be made again. I'm not happy with the way this case was handled. And I'm not happy that after all of the pursuit of getting the correct psychological, correct neuropsych, I was told he got a neuropsych and it wound up being just a regular psychological. It wasn't a neuropsych. So we are very far down the timeline in this case. TMC was granted on June 20th of last year. It's July 9th. And as Ms. Fuller's correct, a lot of what was supposed to be done was not done. It's wound up being I don't want to say it's been harmless because I think it's been harmful, but it's wound up putting Lane back at home with his mother. And I'm proud to hear this, Lane. His behaviors have improved and he's handling situations better and he's home. So I'm glad to hear that. I'm glad to know that, but I want to make sure that everybody involved in this case understands this is not the way things should go, and it needs to be a learning experience. And I want to look at this documentation. I want to figure out everything that went on, and I'm even going to review my own decisions, and I'm going to review my own findings and my own orders, and I'm going to make sure that every little thing is covered. And whatever I come up with, I'm going to share that information. I'm way over budget, so I need to get done with this. But the last thing I want to say is that we've been in this process, community-based care, being online for a while now. And I've recently been made aware of a lot of concerns, some of which are similar to what I'm hearing today. And I've polled attorneys, and I've polled CASA, and I've polled other people, and we've got a whole list of concerns that we're working on that I'm in communication with Belong about. And it's things like this that we need to work on so that, as Ms. Fuller stated, we're not branding people for life with information that's incorrect, and people are getting the services that they're supposed to get timely. So let this be a lesson. I'm going to grant the dismissal. Congratulations, Ms. Grissom. Congratulations, Lane. I hope that we never have to see either one of you again in our courtroom. And I hope that everything for you goes well for the rest of the summer, and that you have a happy life together as things progress. And I share with Ms. Fuller that for anything that went wrong in this case, you have my apologies as well. All right. Anything else anybody else wants to add?
I just want to make sure that there will be some recourse if she doesn't get those payments. You know, I know I asked for it to be dismissed. I wanted it to be dismissed. I know that's on me too, but
Ms. Rush, I've ordered them to look into it. Obviously, I'm dismissing the case, but Ms. Rush will keep me updated. If you just make sure Ms. Greenlee knows what's going on, and we're going to keep looking into this.
Yes, sir. And I don't want the court to misunderstand. I cannot promise that we can get the payments back.
I understand.
I can just contact the person in the state office who does this and have them see what they could do with Social Security.
All right.
And I trust Ms. Rush, Your Honor. I really trust Ms. Rush. I feel like she will do what she says that she's going to do. I don't want this to slip by just like on CPS's end, not on her end, and have it, you know, not be resolved in some way.
Well, Ms. Rush, if you just keep my office updated and keep updating Ms. Greenlee and let me know what you find out.
Well,
we'll track it down.
I will email Ms. Greenlee and Ms. Fuller. Mr. Saldivar, do you want to be included on an email when I find out something?
Yes, please.
Okay, I'll make a note. Thank you, sir.
Okay. That'll be it. There are no further hearings. All parties are excused. Thank you for your time and your service. And nothing further. All parties are excused.
Thank
Thank you, Judge. Have a good day.
Thank you.
I saw the mother, Miss Constante. Can you turn your video back on, please? All right, ma'am, I need you to be in the picture and be still, and please no smoking while we're in court. Is Mr. Taylor there with you?
No, Your Honor, they're not a couple.
All right, I'm just making sure because I don't see him anywhere, and I just wanted to make sure he wasn't by any chance there.
Your Honor, to my understanding, he's at work.
Okay. Court is broadcasting via Zoom and YouTube from Kendall County. Are there any objections?
No, sir.
No objection.
No.
No objections.
Then Ms. Rush, with that, would you please begin the announcements?
Ursula Russian, owner Powell for the department. Ready?
Christy Cannot, Permanency Supervisor with Belong.
Quincy Brandon, attorney for the mother, present, ready.
Alana Pearsall, attorney for the father. I'm going to announce not ready since he's not present.
Marco Cabrera, attorney ad litem, ready.
Jill Roden, Tri-County CASA.
Kim Nunley, CASA.
Ms. Constante, could you please unmute and announce?
Vale, Constante.
All right, Ms. Powell, we're going to go over your report. Children, Kinsley is 11, recently placed in a foster home in Bear County. Is that correct?
Correct.
And is that placement at this time safe and appropriate, meeting her needs?
I apologize, Judge. They've recently been removed, but at the time of the report, they were in a foster home.
Okay. What date were they moved again?
They were moved yesterday on the 8th.
And were they moved together?
Yes, sir.
Where are they now?
Light Village in Seguin, Texas.
So they're in, was that Guadalupe County?
I believe so, yes.
And is that foster care?
They were put on respite for now, but it is turning out, it may turn out to be a temporary placement right now.
What kind of placement is it?
It's a GRO.
GRO. Okay, that's fine. All right. Is that GRO, to your knowledge, safe and appropriate, meeting their needs?
Yes, sir, to my knowledge, yes.
Have you been there?
I will go this afternoon after court.
All right. Who placed them there?
Foster mother asked that they be removed from the home.
So who physically took them there?
The foster mother.
Have you been in contact with somebody at the GRO since yesterday?
Yes.
All right. And then what report did they give you as far as how the children were when they got there?
That they were doing fine. That they understood that they would be there temporarily. That was the best they could give me.
Okay. All right. At the time your report was filed, there's no Indian child status. Is that still the case?
Correct.
And children are both up to date on their checkups?
Yes, sir.
Permanency goal is still family reunification?
Yes, sir.
Do the children have any medical, dental, vision issues that I'm not aware of at this time?
Journey has rheumatoid arthritis, but other than that, they're healthy.
And is that being appropriately addressed?
Yes, sir.
And what's the plan in the fall for school?
The tentative, well, at the time, the plan, they were in the foster home, the plan would be for Journey to attend Head Start, and Kinsley would go over to the 7th grade at Judson Middle. So either way, we're hoping to get Journey into a Head Start program.
Okay. So do you believe that their educational needs have been appropriately addressed, or do we need further orders today?
At this time, they've been addressed.
Is this GRO that they're in the least restrictive placement available at this time?
At this time, correct.
And to your knowledge, I don't see it in the report, but I just want to make sure neither one of them are receiving any type of psychotropic medication.
That is correct.
Okay. How are their behaviors?
There have been some incidents in the foster home with physical aggression against the other 2 children who live in the foster home, the adopted children of the foster mother. There've been a few incident reports that have come out with hitting, some pushing, some bullying. And on Sunday, I believe there was an incident between Journey and the 2-year-old that resulted in the foster mother asking that they be taken out of the home.
Okay. Are they in therapy?
Yes, their therapy was a bit delayed, but they are with the Pursuit of Happiness. Their therapist is Nathan Orana, and it was just getting started. So
are they not going to be able to go there anymore?
They can. The therapist can travel to them throughout the state, no matter where they are in the state of Texas.
Okay. Let's talk about Miss Constante. Is she in compliance at this time?
Not at this time.
All right. What does Miss Constante need to do in order to be in compliance?
We'll need drug testing. I've already put in for another OSAR referral. She missed her appointment with OSAR. It was set up. She missed her appointment. She was incarcerated briefly. She'll need to complete parenting, individual therapy, and we need to address some mental health issues with, and I always pronounce it wrong, MMHR.
Okay. And I don't think I said this, Ms. Pearsall, I apologize. You're not ready is overruled. Your client was served, is aware of these proceedings. And I think you said he was at work. So we're obviously moving forward, but I just want to make sure it's on the record. Does Miss Constante have a copy of her family plan of service?
Yes, she does. She has a digital copy, and I gave her a physical copy the other day at the visit.
And have you discussed it with her?
Yes, we discussed that in our monthly face-to-face on Friday.
All right, now let's talk about Mr. Taylor. Is he in compliance?
No, sir.
What does he need to do in order to get into compliance?
He'll need to begin his services.
Has he done anything?
No, sir. I've been unable to get a signed release from him, but I do have a better address for him. So hopefully I will be able to get out and give him that family plan of service and go over that with him and send out his referrals.
What were the initial concerns that brought these children into care?
Mental health issues and substance abuse.
To date, has either parent addressed those issues sufficiently?
No, sir.
Miss Constante has missed several drug tests, correct?
Correct.
And she's been incarcerated throughout the course of this case?
Not throughout the entire course. I believe she might have been incarcerated 2 or 3 weeks.
Do you know what the allegations against her were?
I believe it was a violation of probation.
Okay. Would it be safe to return to either parent today?
Not at this time.
What about visitations? Do you believe that they should continue?
I do believe visitation should continue. We've been having some difficulty with distance, but I do believe visitation should continue.
And is it belong that's supervising them?
Yes, sir.
And you believe the current visitation schedule is appropriate?
Yes, sir.
Okay. CASA was concerned about speech evaluation services for Journey. Has that been addressed?
Not at this time, simply because they're out of the home now, but they were, a referral from the PCP was in the works to get her speech therapy.
Okay. All right, Ms. Rush, do you have questions for Ms. Powell?
Yes, sir. May it please the court. You show on your report dated whatever date, that you had a UA and a hair follicle pending on the mother from June 21st, 2024. Do you have the results?
We never set it up for her to test.
Okay, then I don't understand. Why does it say UA pending?
I'm sorry, that was on mine. That was a mistake on my part.
Okay, so you've never had any drug testing of the mother completed, is that correct?
Correct.
Okay. You say that both the mother and the father report stable housing. Have you been to either one of the houses?
I've not been to Mr. Taylor's house. I've just gotten a new address for him, a better address. And with Miss Constante, we've not been into the home at this time. Because I've never been out there. I've always been transporting the children to her at another location.
Okay. So it's not because she hasn't let you in the house.
Correct.
The new address, is it the address you've listed on your report for Mr. Taylor, or is it an address other than the address in San Antonio?
I believe it's another address in San Antonio.
Okay, so he's no longer living with his mother?
Believe he said he still is.
So his mother moved?
No, when we got the addresses for Mr. Taylor, they were pulled from a due diligence report. And
Okay,
it was never confirmed.
so the address on Sunrise Terrace, you believe, is where he's living with his mother?
Yes.
Okay, I'm with you now. You want the video and phone calls to continue between the parents and the visitation schedule?
We would like the telephone conversations to be once a week, the visits to continue weekly, and the phone conversations cut down to once a week.
So you do want the current visitations changed?
Yes.
And when you say phone, is that like phone, FaceTime, whatever, anything like that?
Yes, ma'am.
Why do you want it cut?
It was proving to be an issue with any of the placements the children have been in. With the constant, Ms. Constante would get the telephone numbers of the caregivers and continue to call, and then there were some behaviors after the phone calls. And we just, maybe for them right now to be lessened.
Are you going to
Until
have
further
a problem with that in the group home?
notice. Hopefully we should not. The phone calls will be supervised.
Have you checked with the group home to see if that's going to be possible?
Yes, they've sent me out the contact list to add Ms. Constante to the list.
Okay. I don't know who's talking, Your Honor. And I just want to make sure, since the incidents you're discussing between the children and the other children in the home, none of them were of a sexual nature, correct?
Correct.
Okay. And finally, how old is Journey?
Journey is 4 years old.
As I understand it, once you reach 3 years old, the school district in which you reside is required to do testing for speech therapy and provide you with speech therapy. Have you looked into that for Journey?
With Head Start, yes, myself and the foster mother.
Okay. So when you say that the speech therapy, she can get state mandated speech therapy from the school district when it starts, correct?
Correct.
Okay, pass the witness.
Mr. Brandon?
Thank you, Judge. Just to follow up on a couple of things. So as far as the mom's service plan, have all the services been set up and all the referral forms made?
Yes, sir.
Okay. And then as far as going to see her house, do you have any plans set up to go see her house?
I can do that this Friday.
Okay. All right. And then as far as you're wanting to cut down visitation, is there any indication that we're going to have any kind of issues at the group home?
I'm sorry, could you
You
repeat
want to
that?
cut the phone calls down? Yeah, I'm sorry. It glitched on my end too. You indicated that you wanted to, you just told the state's attorney that you wanted to cut down on the phone calls between the children and the parents. Is that correct?
Correct.
Y'all hear me now,
I'm
Judge?
going to give you permission to turn off your video
Okay.
so that we can use that extra bandwidth for your audio. Go ahead.
All right. Does that sound better, Judge?
Yes, sir.
Okay. So my basic question was, is there any indication that there's going to be any issues with phone calls between the parents and children at the new placement?
There's no indication at this time.
Okay. Would it be better suited to wait and see if there's going to be an issue as opposed to cutting down those visits currently?
I can agree with that, yes.
Okay. All right. Pass the witness, Judge.
Ms. Pearsall?
We are here today at about the 6 months mark, correct?
Yes, ma'am.
Have all of the father services been set up as of today?
No, ma'am. I didn't have a release of information, but they can be done. I can do that today.
Okay, so
Simple
sitting here,
referrals.
so as of today, none of the referrals have been set in?
Not for him, correct.
And father, has appeared at the family group conference, correct?
Correct, he has.
Okay. So you've had some limited communication with him at least.
Yes, during the meetings.
Okay. No other questions, Judge.
Mr. Cabrera,
I have no questions, Your Honor.
any other witnesses from anybody?
Your Honor, may I ask her one question?
Sure.
Ms. Powell, do you currently have a release for the father?
No, ma'am.
That was all I wanted to know. Thank you, sir.
Anybody else have any other witnesses or questions?
Nothing, Judge.
Okay. Mr. Cabrera, what are your thoughts on things?
Your Honor, I've met with the children a few times. I know they're having behavioral issues. I deeply feel that that those behaviors are due to trauma-based events in their past. When I met them, they're sweet kids, and you don't really get that from the reports. I know therapy's been difficult having them move around, but I do think that's a priority. There's also been some talk about the kids maybe needing to split up if we can't find a placement for them together. I think it is a priority to keep them together, but I think we are coming to the point where that ability may not be possible.
All right. Miss Roden, Miss Nunley, anything else that you want to add?
Thank you, Judge. I think one of the most important things too is to make sure the counseling gets started. I know they've done their intake, but I don't think they've had a session yet. So I think that's important for both of them. And keeping them together. I'm in complete agreement with Mr. Cabrera that keeping them together is very important if we can. That's all. Thank you.
You're welcome.
Your Honor, I just wanted to add a couple of things real quick. I know that we had some recommendations and requests in our report that didn't get a lot of coverage. We are okay with reducing the phone calls, but those phone calls haven't been happening for several weeks. We've reached out in both a meeting and by email because it is a court order. I think the girls are struggling a little bit. And I think that those phone calls and having some contact with mom would be appropriate. I want to see that those court orders get followed. And that's kind of a priority to everyone. Like I said, we are okay with the reduction and we do want to make sure that Belong or even CASA, I'm willing to assist in supervising some of those phone calls. But I do want to see that those are supervised by somebody on the team because there have been some questions to those and because the behaviors of the girls have escalated recently in this most recent placement. I just want to ask, I know that you've heard the attorney online and Ms. Nunley both talk about sibling separation, but I would request that we make a court order to not separate the kids until there's been some sort of, there hasn't been any attempts at therapy. The psychological report for Journey requests that they, like in the placement recommendations, recommends the girls stay together. They've just had a hard time being away from Hondo, and I think to separate them without attempting other interventions first would just be, it would be a big mistake and there would be long-lasting effects to both the girls. Thank you.
Okay.
And Your Honor, if I can add, Mr. Taylor really wants the girls to stay together, and he's not even the father to them both, but he understands the importance of their relationship to each other. And so he's supportive of CASA and is asking the same thing.
Miss Roden, why is it, in your opinion, that these phone calls are not occurring?
In my opinion, it doesn't seem to be a priority.
And for the purposes of the initial permanency hearing, the court finds there's no any child heritage in this suit. Court finds that the permanency goal is family reunification. At this time, it's in the best interest of the children. We're 6 months through the case, so I know we've got some work to do. Court finds that the children were placed in a GRO respite care facility on July 8th, 2024 in Guadalupe County. The information presented to the court is that this could be a temporary placement. So I'm going to find that at this time, under the circumstances, it's safe and appropriate, meeting their needs. I'm going to order Belong to make an in-person visit there within the week and to check on the children. And then by Friday, and I'll find that this is the least restricted placement available. Court finds the children are up to date on their checkups and that Journey's arthritis is being appropriately addressed at this time. Court finds that the children, at this point in time, their educational needs are being met. It's summertime, but I want to make sure that there's a plan in place to make sure the children get where they need to go. Ms. Rush did elicit testimony that there would be some required testing, but I want to make sure Journey can get the Head Start and Kinsley can give it to Judson Middle School as planned. The physical aggression concerns me. Hitting, pushing, bullying, being moved from a placement. So I want to make sure that therapy starts ASAP, or whatever it takes to get them into therapy. I don't want to find out that it took a month from today's hearing for them to get into therapy. It needs to be within the week. So I'm ordering that they begin therapy within the week. And whether that's with Mr. Arana or Pursuit of Happiness or somewhere else, they need to get in there. So that order is, I'm being very specific. I want them in therapy within a week. And if Mr. Arana can travel, I don't see why that can't happen. We got to work it in. I'm going to find that neither parent is in compliance this time. I know Ms. Powell had put in her report that mother was in partial compliance, but we're here because of substance abuse and mental health issues, and I'm not seeing those get addressed very well at this point in time. I hope that things can get better. I truly do, but we're just not there yet. We're 6 months in, and we're still missing drug tests and not signing releases, and we're just not getting there. I find that neither parent has appropriately addressed the concerns that brought the children into care, and it's not safe to return the children to either parent at this time. Because I'm hearing that the visitation is still appropriate and in the best interest of the children, I'm going to continue it once per week, and the phone calls. I'm going to order belong to make sure the phone calls occur and allow authorized order CASA to assist however that works out. I'm going to order speech evaluation services for Journey, and I'm going to make an order if there's no separating the girls without a court order. Our next hearing is going to be October 8th, 2024 at 9:30. October 8th, 2024 at 9:30. Anything I failed to address besides the admonishment?
Your Honor, if I may, did you say you want the current phone call schedule to remain, or are you reducing it to 1 week? I sort of lost something there.
Reducing the visitations to 1 week. I think the phone calls can be the same, because I heard concerns that the phone calls might be disrupting placements, but I don't know how that's happening if they haven't happened for a month, as Ms. Roden testified. So it's kind of hard for me to say with the information that's in front of me. I think the gist of what I got is that the phone calls need to continue.
Yes, sir.
And so for there to be adequate phone contact, if that needs to occur more than once per week so that the children are getting what they need as far as phone contact goes, I'll allow that.
Thank you, sir.
I don't want to give you a vague order. I think a minimum of once per week, but multiple times a week are authorized, provided that the phone calls do not disrupt placement and remain in the best interest of the children.
And are you asking that they be supervised by CASA or belong, or did I misunderstand that as well?
Have the phone calls been supervised in the past, Ms. Roden or Ms. Powell?
Yes, they were supervised by the caregivers.
I want to make sure they remain that way, because I've got parents who aren't in compliance yet.
Yes, sir. Thank you, sir.
You're welcome. And I have to make the admonishment that the state of Texas gives parents in CPS cases 12 months to demonstrate they can provide a safe, stable, violence, and drug-free home for their child or children. If they cannot do so, their rights to their children are subject to restrictions as they are now, or termination. Thank you all for your time and your service. If nothing further, all parties are excused.
Thank you, sir.
Thank you, Your Honor.
Thank you, Judge.
Thank you, Judge.
Your Honor, the parents' attorneys wanted to talk without us for a couple of minutes.
The parents are aligned, correct?
I do believe so, but is it Ms. Pearsall and Ms. Acevedo just wanted to discuss among themselves for a couple of minutes.
Okay. All right. Have you all been able to come to an agreement, or do you need a hearing? What are we looking here?
Hearing for the judge.
There's an agreement. Okay.
Objections.
With that, Mr. Rush, would you please begin the announcements?
Ursula Rush and Christina Berciaga for the department, ready.
Desiree Flores, FBSS Supervisor, observing.
Alexandra Vanderbilt, Child Protective Investigations Supervisor from Berciaga.
Jennifer Harris, attorney ad litem for the child. I'm ready.
Melissa Barrientos, family-based caseworker.
Alana Pearsall, attorney for the mother, Ms. Ballou, who's present. Ms. Ballou, can you unmute and state your name, please?
I'm Victoria Blue.
Rochelle Acevedo for the father, Mr. Mascarenas. If you could please announce.
Michael Mascarenas.
Ms. Rush, do you want to state the terms and conditions of the agreement?
Your Honor, the parties have agreed to a Texas Family First order for this family, in which the parents will participate in the services as set out, which includes a psychological, wait a minute here, for the mother, which can be a psychological or an MHMR assessment, counseling for the mother, drug and alcohol testing for the mother, compliance with the family service plans, for the father, drug and alcohol assessments and drug testing, and compliance with the service plan.
Is that the entire agreement?
Yes, sir, I do believe so.
All right. Ms. Berciaga, would you be giving testimony on this?
Yes, sir.
There you
All right. Do you believe that the services that Ms. Rush has stated on the record are appropriate and necessary for these parents?
Yes, I do.
Is everything that was in your affidavit that you filed, to your knowledge, still true and correct?
Correct. The only thing that was corrected was Miss Victoria had informed me that she had taken the gummy before bed instead of before work.
Okay. So your testimony is that abuse or neglect occurred, or there's a substantial risk of abuse or neglect or continuing danger to the children's physical health or safety caused by an act or failure to act of the parents?
Yes, sir.
You believe family preservation services are necessary to ensure the child's physical health or safety?
Yes, sir.
You believe family preservation services are appropriate based on the safety risk assessment and the child's family assessment?
Yes, sir.
Okay. Ms. Pearsall, is that your understanding of the agreement?
It is, Your Honor, but I would like to add that mom, and I'm assuming dad, but honestly have no personal knowledge as to dad. Mom has been amazingly compliant. She has already started services. She's already passed 2 drug tests. I don't remember in recent history, at least, a client who wanted services so badly and was so willing. She took 100% responsibility for what happened. I'm just beyond impressed with her. So I really am impressed and think she's doing a really good job, and it's very unusual and should be acknowledged.
Well, I'm glad to hear that. That's a good start.
Your Honor, I did leave something out. I apologize. Included is with the mother's parents as teachers. That's the parenting class it'll be.
Okay. Thank you. Ms. Acevedo, is that your understanding of the agreement?
It is, Judge, and I would just reiterate Ms. Pearsall's feelings as far as the parents' cooperation. Dad was in the same position, very compliant since the beginning, I think, and we've both explained to them we're in this particular weird circumstance where they fall under that Texas Family First, and it's required. But again, Judge, they are very, very compliant. And they've been so since the very beginning.
Good. Ms. Harris?
Yes, Your Honor, I'm in agreement.
Anything else that you want to add?
No, I think that this is the kind of family that these services are especially made for. So I'm very hopeful that we can get through these as motivated as they are.
Okay. Well, based on the agreement of the parties, one thing I don't have in my system is, were the parents served?
Yes, sir.
Okay.
Yes, sir.
All right. Do you know the date of service, Ms. Rush?
Yes, sir. If I could just have a second.
While you're looking that up, I'll go ahead and state that they, at the
Thank you,
very
sir.
least, made an appearance today by and through their counsel and in person. And there's sufficient evidence to satisfy a person of ordinary prudence and caution that abuse or neglect occurred, or there's a substantial risk of abuse or neglect or continuing danger to the child's physical health or safety caused by an act or failure to act of a parent. Family preservation services are necessary to ensure the child's physical health or safety. And family preservation services are appropriate based on the child's safety risk assessment and the child's family assessment. And the court will order the services as stated on the record by Ms. Rush and agreed to by the parties. Find that they're narrowly tailored to address the factors that make a child a candidate for foster care. Going to make those orders of the court today. We'll have a compliance hearing on September the 10th. I'll move this window over. September the 10th, 2024 at 11:30 a.m. That's September 10th, 2024 at 11:30 a.m. Ms. Ballou and Mr. Mascarenas, I want to make sure you understand this is the least restrictive way for you to receive services through the Department of Family and Protective Services. Beyond this, it gets much more intense and much more invasive on your life, and it becomes a very different type of legal case. If you do what you're agreeing to do here and you don't just check boxes, but you actually engage in this stuff, then this can go very quickly and everybody can be out of your lives very quickly and you won't have to come back to court. If you go the other route, it won't go as quickly and it'll probably get more intense and invasive on your life and your family. And I can tell you that none of us here want to see that happen. Got several resources available to you. You've got people who can help you through this. Take advantage of that and get to work on it. Did you get those service dates, Ms. Rush?
Yes, sir. They were served on June 26th.
Was personally?
Yes, sir.
Okay, thank you. All right, so we will be back on September 10th at 11:30 for that status hearing. And I hope to hear a lot of great things having been done by that date. Anything I failed to address?
Not from the department. Thank you, sir.
Okay,
Thank you.
good luck to you both parents. Thank you all for your time and your service. If nothing further, all parties are excused.
Thank you.
I appreciate it.
Thank you.
No objection.
With that, Ms. Rush, would you please begin the announcement?
Versal Rush and Matthew Schaefer for the department ready.
Desiree Flores, FBS Supervisor.
Jennifer Harris, attorney for the respondent mother. Ms. Richardson, please unmute and say your name.
Sarah Richardson, mother.
Irene Acosta, attorney for the father. Mr. Mangold, can you please announce your name, please?
Maury Mangold, father.
Deborah Fuller, attorney ad litem for the children.
Michelle Tavini, program coordinator over here with DePelchin.
We were last here for our services case. Actually, two settings. We were here on June 24th and went through several things, but basically at the end, I granted the TFF with a zero tolerance policy, and I made it very clear that I expected Miss Richardson to do NA classes, 90 meetings in 90 days, beginning the day after the hearing. Otherwise, should be ordered to inpatient. And I set this progress hearing. It stated that if the parents are not in 100% compliance, if there's any other issues, that I would dismiss the case. Where do we stand, Mr. Schaefer?
Well, Your Honor, I'll start with Mr. Mangold. He has been in compliance with his family plan of service. He initiated his own drug and alcohol assessment through a community resource with South Texas Rural Health and Divine. So he has actively been engaging in that weekly and attending those sessions with outpatient treatment. However, on the past court hearing, we wanted to do an actual OSAR. So his OSAR assessment is still scheduled for July 22nd at 9:30 a.m. So he will participate in that. And depending on the outcome of that assessment, it could still be in outpatient services or recommended for other services. So we'll see then, but at least now he's engaged in outpatient treatment. He has provided me with 2 negative random UAs for the month of June. He was referred for his psychological, I believe, earlier last week or so. He did initially get it scheduled for, unfortunately, it was today at 9 a.m., but due to the conflict of court, I reminded him yesterday to try to get that rescheduled. So it was not a conflict with any of the services he's been engaged in. So he has been referred. That just is pending for rescheduling. In regards to, I want to kind of go to the kids. The kids have been fine. There's been no issues with the kids whatsoever in their care. I've seen them multiple times in the home and the environment that they're in. I've assessed the home, and there's been no concerns for the children in the home. They've been well cared for. Miss Richardson has actually took it upon herself to get the kids engaged in individual counseling and got that set up for them on July 3rd at South Texas Rural Health with Ariana Hernandez, and that's to address the previous experiences of going through a CPS case, being removed in foster care. So the needs currently being met for the children. That was just something additional that has been brought up that mom wanted to make sure was done. I will go into Ms. Richardson shortly, but I do wanted to say that the parents have not yet started the brief strategic family therapy yet, as we've talked with DePelchin, and we are kind of pending the outcome of this court and also possible direction of the case headed in a different manner with Ms. Richardson going to treatment. So that has not actually started yet, and it's not counted against them. It's just with DePelchin and the department communicating, they have not proceeded to start that initially, so I don't want that to count against them. So in regards to Ms. Richardson, she too has been very compliant with the services. She's been attending NAs every day. I've been getting screenshots into the late evening showing that she's participating with different ones virtually. So she's been in compliance with that, making sure that she's not missing any type of NAs. She has also took it upon herself before TFF occurred that she got into an outpatient program as well with South Texas Rural Health with James Valdez, who the LCDC is, and has also been attending weekly sessions as well. She was initially scheduled for an OSAR on July 22nd at, I believe, 11:30 a.m. So that is technically pending. However, talking with Ms. Richardson, she was actually willing to and agreed to enter into inpatient treatment at Journey Recovery, which I know you're familiar with. And she did participate in a screening over the phone at the end of July, or excuse me, at the end of June, I believe on the 28th or the 29th, where she was recommended and referred into inpatient treatment. I was able to secure a bed for her, which was supposed to be as of yesterday, July 8th, where she was to enter in with her child, Doc. Fortunately, due to some other circumstances that I'll get into, that was put on hold. She too has actually provided negative UAs for the month of June as well. Just unfortunately, I did send both Mr. Mangold and Ms. Richardson for hair follicle testing to get more of a baseline reading to give to the OSAR assessor so they have a clear understanding as to past drug use that coincide with the negative UAs, just to have a thorough assessment done. Mr. Mangold did participate and did his hair follicle test and was actually positive for methamphetamines. Miss Richardson was positive for methamphetamines and marijuana. I contacted the facility today, actually, and verified because we assumed that there would have been other substances that may have come up in the testing based on previous urine screens done prior to family base being involved. And I was instructed that the next time that we do a test, we need to actually let the facility know that's actually obtaining the specimen of what certain panel that we want being done that's going to test for other substances. So we make sure that everything's tested for to see if anything does come back positive. But anyway, as I was saying, she did, like I said, participate in her screening. She was due to enter into inpatient treatment as of yesterday. Where this comes into play as things be put on hold is the fact that, unfortunately, with Miss Richardson taking the initiative to get her children engaged in counseling on their own or on her own accord, I was able to confirm that both Miss Richardson and Mr. Mangold were or did, in fact, break the safety plan on July 3rd. And that was basically just me contacting the facility, kind of asking if the children came in and if got set up for their intakes. And Miss Richardson and Mr. Mangold were alone with each older child, Colby and Nick. So they were at the facility. Mr. Mangold technically is not required to be supervised as the safety plan was implemented for investigations, but he was not to be the one to supervise Miss Richardson's contact. Miss Richardson did not have an appropriate caregiver or supervisor with her present to supervise her contact at that time this took place. The main caregiver or supervisor caregivers, the maternal grandparents, were not aware of this, as Miss Richardson and Mr. Mangold were residing at Mr. Mangold's grandparents' home, who we no longer are able to utilize as appropriate supervisors for them. But they allowed Mr. Mangold and Miss Richardson to leave the residence alone with each child to take them to their intake. So where we are right now is both parents were in 100% compliance until this little incident of breaking the safety plan on July 3rd, in which Ms. Fuller wanted to make sure that the court was heard in this aspect of her decision about the child going with Ms. Richardson. But the intent is for Ms. Richardson, from the department's perspective, is to enter into inpatient treatment at Journey Recovery with Doc present with her at that time.
Thank you, Mr. Schaefer. Mr. Rush, do you have any questions for Mr. Schaefer?
Not at this time. Thank you, sir.
Ms. Harris?
Is the inpatient facility where Miss Richardson has been accepted a facility where children can also participate?
Yes, the children are allowed to attend, and based up to a certain age of the child, they are able to participate in certain classes.
And did she request that she be allowed to take the baby with her?
Yes.
And was Belong in support of that?
I'm sorry, belong who?
I'm sorry, was the department in support of that?
Yes, ma'am.
And was the facility in place of that?
Yes.
I'm sorry, in support of that. Why is it important to the department that she be allowed to take the baby with her?
Well, if I may, I'm going to kind of result to some of the information that I kind of shared with some of the other attorneys. But with Sarah going into inpatient treatment with her child, she would be engaging in parenting on her own accord with other parents that are in the facility engaging in parenting. However, the fact that she has a child, she would be separated from that parenting and having her own parenting individualized class or group tailored around her child's cognitive abilities, developmental abilities. They call it kind of like a parent-child lab is how they call it. So it's really tailored to his age and her one-on-one, the bonding, the nurturing together, the just individualized alone. And what this does, it helps to incorporate her skills and techniques that she's learned in treatment and apply them as a role as a mother while she manages her recovery and addiction and balancing both roles and duties. This allows her to also have the feelings and preparation of learning how to actually be a sober mother while also maintaining her sobriety as well. This allows her to also adjust herself to the balance of both now and getting used to this sobriety as a mother rather than her being implemented back into society and just trying to like it all being handed to her at once just to be overwhelming. So it allows her to do this inside the facility in a controlled environment where there are other staff, there's other support system, controlled environment there to actually help her while she's engaging in this. And by doing this, this would also provide a smooth transition, back in where the department can monitor when she's out, where, you know, the recovery has a better chance, you know, of being successful.
Do you have any concerns about the safety for the baby if he is taken to the facility with his mother?
No, I've worked with the facility before, and I actually double checked with the director as to some of the safety measures that they have in place. They have cameras in all public areas inside and outside the facility. They have alarms on the doors and the windows. They do 15-minute bed checks throughout the night. The children are in childcare during the day, during the group settings, and then parents, of course, pick up and tailor their care around towards the afternoon. If by any time that Ms. Richardson was to try to leave or request to leave, the facility would not allow that without our permission, and or if for some odd reason Ms. Richardson was able to actually get out those front doors, 911 would be called along with the department as well. But I don't have any concern for that taking place.
Is that what you would ask the court to approve today?
Yes, from the department's position, yes.
And why has she not already gone with the baby?
It was brought to our attention that it may be best for this to be held off to let the court to decide today in the aspect of Ms. Richardson going into inpatient treatment with or without her child.
Do you think that it's important that she complete inpatient treatment?
Absolutely. The fact that she was willing to go already set a different path than what she's ever done before. Yes, she's completed a 30-day program, but you know, clearly not a 90, and she very well could have benefit from an additional 60 days from when she did that original 90 or 30 days. So the fact that she's willing even to go for this long is, I mean, it's a step in the right direction than what she's done before. And yes, I feel that the whole 90 days would give us some sort of better understanding and also a different level of care in her sobriety as well.
No further questions, Judge.
Well, oh, I'm sorry, Mr. Costa.
Thank you. Mr. Schaefer, is there anything else that Mr. Mangold needs to be doing currently to remain in compliance?
No, not at this time. Depending on where we go with the brief strategic therapy, if they're going to stay in or not, whether Ms. Richardson goes with her child to journey recovery or not, will then dictate how this plays out in regards to family therapy. Whether if they stay involved, then okay, family therapy can occur if and when Ms. Richardson gets out, or if family base just takes over and initiates family therapy once Ms. Richardson gets out. So Mr. Mangold, like I said, testing, he's already engaged in outpatient. He has another OSAR coming here in July, and he's already, you know, been in communication to get his psychological set up. So at this time, no, there is nothing in addition that he needs to be completing.
Thank you. I'll pass the witness, Your Honor.
Ms. Fuller.
Mr. Schaefer, in regards to this case, when you got this case, were you aware that Mr. Mangold was using drugs, methamphetamine and heroin as well?
It wasn't until I initially sat down and interviewed both parents where I was able to obtain a little bit more additional information about his past use.
And so that was not one of the concerns that brought the children into care because you thought that he was clean and sober, correct?
Yes, when it came over to family base, that's correct.
But he did test positive for methamphetamines on the hair follicle?
Yes, in addition that Mr. Mangold was and has been very honest about his past use, that he did admit to using methamphetamines, maybe some THC as well, and some heroin 5 weeks after his child was born.
Okay. And in regards to domestic violence, has that been brought to your attention as well?
Yes, during my initial interview with the parents, just standard questions that I ask, and I felt that when I got to that topic of conversation, just kind of went with my gut instinct. It didn't feel right. So what I wanted to do is I went ahead and did a address survey on the previous residence that both parents resided in, and we did get some reports back. I shouldn't say reports, more like call sheets and just notations of calls made to the home that could indicate possible concerns for domestic violence in the past.
And so what is your understanding of that situation? And that was when they were in their apartment in Divine?
Yes, that is correct.
So did you discuss that situation with them?
I mentioned it to them last week when I met with them both to address the breaking of the safety plan and some other information, that if the violence was occurring, if not, we have a concern that there's possible or could have been that's just ideally something that the department would proceed moving forward, addressing that therapeutically, whether again, that's with DePelchin being involved in family therapy, and or if they're not, then we can do couples marriage counseling while addressing the domestic violence as well within that.
So based on Mr. Mangold's drug use and the domestic violence, do you feel that he should be unsupervised with his child?
So I know that the hair follicle does show that there's past use. I do have the evidence that we have where Mr. Mangold was tested negative.
My question is, do you think he should be unsupervised with his child or with the children that are not his?
At this current time, yes.
You feel that even though there's positive drug tests, admitting drug use and domestic violence, that he should be left alone with children that aren't his, one, and with a baby?
So,
Your Honor, I'm going to object to the way that the question is being asked. There was no testimony that there was actual domestic violence. There was testimony that there were call sheets that could possibly have indicated domestic violence, but not that there was actual domestic violence.
Allegations, Your Honor, of domestic violence.
So I'll sustain the objection. You can rephrase your question and pursue it again if you want to, Ms. Folk.
So the department has no concerns about Mr. Mangold. Is that what you're saying?
Currently at this time, no.
Okay. And when you notified the attorneys that there was a violation of the safety plan, you mentioned that this was the second violation of the safety plan. When was the first violation?
To my knowledge, I believe when I participated or sat in and observed the previous court hearing that occurred, I believe there was a safety plan being broken by the parents as well at one point where I believe Mr. Richardson had left with the children. That's to my recollection.
Okay. And when you found this out by accident, it wasn't like, you know, they were honest. You found it out by calling the facility, correct?
Yes, ma'am.
You know, and the court made it very clear that this is a zero tolerance case, correct?
Yes, ma'am.
And you feel that violating the safety plan is not important?
It is important. You know, when I did address it with them, neither parent did deny it.
Well, you caught them. How could they deny it? I mean,
yes,
really?
it is a concern that was being broken. Yes.
Okay. And so, Mr. Schaefer.
Yes, ma'am.
You understand Ms. Richardson's drug history probably, you know, better than anybody else here. You've dealt with her before, correct?
Yes, ma'am.
And so, focusing on her drug issues, she's never really done that in an intensive 90-day treatment, correct?
That is correct.
And you feel that placing her baby with her from the very beginning will help her when she hasn't concentrated on that in the past?
Being in a controlled environment, yes, I feel like this could lead to a different avenue of sobriety.
And in regards to the program, are you sure this is a 90-day program?
Yes, ma'am. And working with the facility, and Ms. Richardson has the option as well. She very well can ask or be asked to have an extension based on her progress in there. In the
But it's
facility.
actually a 30-day program, and you ask for the extension. It's not a 90-day program, correct?
No, it's 72 to 90-day program.
Okay. And is that just because she's having the baby with her, or is that typical for journey?
A lot of times when the parents do have the children with them, the services or the time there is actually extended a little bit more because of the fact that, you know, they're having to, you know, do the mother role and do other type of classes that incorporate their child as well. So it's clear to say that most likely she will be there 90 if or plus days.
Okay. But we don't know that.
Not till I speak with the actual staff that she's assigned to, ma'am. That's correct.
Okay. And so for her to not be able to just focus on her recovery, you feel that's best that she have her baby there. Just want that on the record.
At this time, yes.
And in regards to her hair follicle, for some reason, it didn't even test for heroin or opiates or anything, even though it says it's a 5-panel test.
Yes, that was correct. And making notation of contacting the drug testing results that we're given. They instructed me that the actual testing facility that obtains a specimen should be told or needs to be told the exact panel that they need to test for in order to make sure that all clear substances are included in there, not just a 5-panel such as what their panel they selected on, I guess.
But Mr. Mangold's had all of them on there, correct?
Can you repeat that?
Mr. Mangold's hair follicle had all the panels on there, correct?
To my knowledge, it was the same panels that was asked to be tested. And again, based on his admittance prior, it was my assumption that another form of substance would have revealed as well, but unfortunately did not.
So do you think it's necessary for them to have another hair follicle so we can have an accurate account of their drug use?
Yes, based on the information I obtained today, yes, that would be appropriate.
And are you adding any kind of anger management, domestic violence, or anything to their plan of service based on those police reports?
So I know in the brief strategic therapy, it was going to be incorporated in that to be dealt with and addressed. However, moving forward, depending on what happens with Ms. Richardson and the child, the brief strategic therapy program may not be involved. And if so, then yes, we'll handle that and incorporate that therapeutically.
And based on those reports that you read, do you feel that Mr. Mangold should be around the children, the children that are not his?
In regards to the reports that I found?
Yes. Because the children were there in these reports, correct?
Yes, past reports. As being involved with the department for this long, with Mr. Mangold as now, and if Ms. Richardson was to not be around, of course, I don't see why there would be a problem to still have Mr. Mangold around. If it is, for the children to have a sense of normalcy of what they've been exposed to, then great. If that's what we're really here for, then we want to make sure that we have that in the event that Ms. Richardson does leave, that the boys do have some sort of male role model.
Now, does the fact that Mr. Mangold's grandparents or whoever was the safety plan for the baby, that they're not allowed to do that because they violated it at least twice, does that play any role in your decision to place the baby with Miss Richardson? Because her mother is not willing to take the baby, correct?
Her mother's not. Well, I'll answer your first part of your question. In regards to Mr. Mangold's grandparents, yes, moving forward, it would not be in the best interest to continue to utilize them. When they were spoken to probably by the previous worker, I can't say if things were actually relayed correctly to them or if they really understood the nature and severity of the safety plan. When I just found out this information, I did staff with upper management and was instructed at this time we could not utilize them. So we will not be utilizing them as any type of supervisory role ongoing. Now, in regards to your second part of the question, the maternal grandmother would, of course, be willing to take Doc full on if she could. But unfortunately, with her health and her ability to fully care for the child, there would not be anybody else other than Miss Richardson to care for her child as a full caregiver. The older boys are a little easier to care for, and the maternal grandmother would have no problem caring for those older two children.
Thank you. I'll pass the witness.
Thank you.
Redirect.
Thank you, sir. Mr. Schaefer, I'm going to end up skipping around, and I'm sorry. So if I lose you, just stop me and we'll fix it, okay?
Okay.
Regarding the hair follicle of the mother not testing for heroin for whatever reason, did you review the clinical management for behavioral screening services screening that the mother did, I believe, in June of 2024?
Oh, yes.
Okay. And in that, she admitted that she had last used heroin, I believe it was May 30th, 2024.
Yes.
Okay. And I understand you're talking about doing another hair test, but she's admitted she used meth within the last 90 days. Heroin within the last 90 days, correct?
Yes, ma'am.
Regarding the concerns regarding domestic violence, have you found any arrests or charges made against either the mother or the father in this case for domestic violence or assault family violence?
No.
Did either the mother or the father admit to any domestic violence by either one of them?
No, just verbal disputes that end up being separated on their own accord.
And did you see in the reports that you reviewed any evidence that an EPO was issued or either parent was asked to leave the home by the officers to do a cool down period.
No EPO nor asked to leave the home. It was
So-
on their free will.
It literally was a call out and nothing happened.
According to the call sheets, that's correct.
Do you know how many call outs we're talking about?
Not precisely. I do believe there's at least over 5.
Would it be fair to say more than 5, less than 10?
Yes, ma'am.
Okay. Regarding the 90 days program, the program is actually, I believe you said 72 to 90 days.
Yes, ma'am.
The extension that you talked about, is that an extension over 90 days that
Yes, ma'am.
either the facility can request the mother to do, or the mother can request of her own accord to stay more than 90 days?
Yes, ma'am.
Regarding Ms. Fuller's concerns about the mother not being able to concentrate on her own sobriety if the child is with her, is it your understanding that there will be sessions solely for the mother in which the child is not included?
That is correct. And I might add that in the event that when the child is placed with Miss Richardson and she does enter into the facility, if for any reason this child becomes a contrary to her recovery, her treatment in any sort, the child will then be asked to leave.
And the parenting that would be available if the child is allowed to go to the rehab center, is that, you know, if that's one-on-one parenting or if that's group parenting?
No, she will be removed. She will be separated after her initial one-on-one parenting with the group to have her own individualized therapy with herself and her child alone.
So it's 2 parentings, group parenting and individual parenting, if the child is there.
Yes, ma'am.
Cool. Regarding the zero tolerance policy that the court made clear at the adversary hearing, was it your understanding that the court said if he found an issue, he would handle it?
Who's he?
The judge.
Yes, it's my understanding that if anything was brought up in regards to the zero tolerance, that Judge Falkenberg would rule with his decision.
And once again, I may have gotten lost. Is it my understanding that if, wait a minute, do you have a possible admittance date for the mother at this rehab facility?
I do. Speaking with staff, I was able to not only push her bed from the 8th, but also did not lose her bed on the 8th.
So
Her
what
new-
is the anticipated
Her-
intake?
Her new entry date is scheduled for this Thursday between the hours of 10 a.m. to 10:30 a.m.
July-
pending the outcome
July
of today.
11th. July 11th, correct?
Yes, ma'am.
And keep in mind, I'm not from there. What town is this place located?
And San Angelo, Tom Green County.
And will you make arrangements to drive or get transport for the mother with or without the child to the intake?
Yes, we have a caseworker assistant already scheduled and set to pick up Miss Richardson with or without the child and take her there and drop her off.
And if she does not make the transportation, will you immediately notify all counsel and the court that she missed her intake?
Yes, ma'am. It'll be same day, guaranteed.
At that point, you consider that a major infraction of any court order?
Yes, absolutely.
The mother is living with her mother, with the children, right?
That's my understanding.
The father's not living there.
To my understanding, he's living with his grandparents, but
No,
there may be
that's
1 or
okay.
2 days that he does.
So if and when the mother goes into rehab, with or without the child, at that point, does this have to cease being a TFF case and have to become a standard court ordered FPSS case?
I would have to wait to hear from DePelchin on that aspect, but that's most likely my understanding what could possibly happen.
Well, I guess what I'm asking you, doesn't TFF require that the parent be in the home with the child?
Yes.
And whether, even though TFF could technically be involved if the child is with the mother at the rehab facility, logistically, that makes no sense. Is that fair?
Yes.
Pass the witness.
Any other cross?
I have. I'm
Yes,
sorry.
Judge, just a couple. When Miss Richardson was unsupervised with the children, with about approximately how long was she unsupervised?
Well, I would say probably for roughly about 5-6 minutes from the time she left the residence and got to the facility where she was there with a therapist and staff.
And when you spoke to the therapist and staff, did they indicate that there were any concerns regarding her at that time?
None.
And have you spoken to the treatment facility about whether it's advisable for her to switch programs in the middle, as in going from No Child With Me to Child With Me program?
I've only spoken to the nature of what can and could occur if it becomes contrary to her treatment. So I won't know until that time comes.
Would the department prefer that she have one consistent plan of treatment while she's there, or would the department prefer that she switch gears halfway through?
Plan to have a consistent treatment through all the way through.
When you're looking at all the options for where Doc would be while Mr. Richardson is in treatment, your choices are his grandparents that are no longer approved, correct?
Correct.
Her mother, that is really not preferable, but would make do if she had to, correct?
Correct.
And a treatment facility that's designed to help women and protect children at the same time.
Correct.
And which is the department's choice?
It would be at this time to have the child with Miss Richardson at Journey Recovery.
And even if this no longer met the requirements of a TFF case, is it your understanding that there's other ways to file amended pleadings for other kind of court supervised cases?
Yes, ma'am.
No further questions, Judge.
Anybody else?
I just wanted to follow up on this domestic violence. Did you have an opportunity, Mr. Schaefer, to read those reports?
Oh, those call sheets, yes, I was able to see them.
Okay, and you said that they were verbal disagreements, correct?
I was told by Miss Richardson that they were verbal disagreements and stuff when I initially met with her back in June 12th. Not in regards to, or that was not stated once I addressed this stuff with her. That statement was made previously.
So, I mean, in the report in August said that she was
Your
pushed.
Honor, I'm going to object to
Objection, Your
hearsay.
And facts not in evidence.
Where are you getting this information from, Ms. Fuller?
I'm looking at the reports that were provided to all of us, Your Honor, that Mr. Schaefer has said that he has read.
Are they part of his case file?
We were all given the reports, I think.
But are they part of his case file? Mr. Schaefer, are those reports part of your case file?
Yes, Your Honor. They've been obtained and uploaded into our system.
However, Your Honor, they have not been admitted as evidence.
Right.
Your Honor, they were only provided to us via email. We weren't given anything as a redacted copy of a file, nor were we given any business records affidavits. I would still object to hearsay.
And Your Honor, I'm just trying to clarify the incidents of domestic violence versus a verbal incident. I mean, and Mr. Schaefer testified that, nothing happened. We have reports that, mom had to be removed
Your
from.
Honor, I'm going to object again. Ms. Fuller is trying to get whatever's in her hand into evidence without having it properly introduced.
And Your Honor, I'd object as misstating the evidence. Mr. Schaefer said when he asked the parents, they said it was verbal. He did not say that the reports said it was verbal.
Well, I would think the reports would reflect what happened, Your Honor, and that's why I was asking him about his understanding. Obviously, the parents are willing to violate safety plans and do other things, so taking their word that nothing happened is kind of ridiculous in this case.
And
I'll move on, Your Honor.
I think that the information in these reports could be relevant to this situation because I made it very plain on June the 24th that this was zero tolerance and the parents knowingly violated the safety plan. And I think that credibility is definitely an issue here. And if the parents are telling Ms. Richardson is telling Mr. Schaefer what happened with these calls and these reports say something else, that goes to credibility, which is why we're sitting here at a progress hearing in the first place. So, Mr. Schaefer, were these records kept in the ordinary course of business?
You kind of rephrase that. I've never really been asked that before.
All right. Well, I'm asking you, you got these records from your case file.
From Divine PD, Your Honor.
Okay, and you put them into your case file.
Yes, Your Honor.
And you entered them into Impact.
Yes.
You got them directly from the police department.
Yes, with the help from my caseworker assistant. Yes.
Are these types of reports that you use to do your job on a regular basis?
It helps to corroborate and gather and obtain more information to do my job
Do
better.
you have any reason to doubt the veracity or the source of these reports?
No.
All right. Ms. Fuller, I want to know what's in the reports. So do you want to introduce it?
Yes, Your Honor.
All right. Is it going to be ad litem's Exhibit 1?
Yes, Your Honor, but I have, I'm gonna have to go through the number of pages. I'm sorry.
All I want to know is what you were trying to get in.
I'm just trying to get in the reports that say it was not just verbal. That's all.
Okay.
And Your Honor, I say that is a misstatement of the facts that are there. She needs
Well, that's
to
why I
get
want to
these
see the
records in.
report. I
And they're
want to
not
see what the
redacted.
report says.
They're not redacted, Your Honor. So there's very important information that should be redacted that should not be on YouTube for this.
Well, then let's go into chambers and let's talk about it, because
Thank you, Your Honor.
where are the parents? Okay. So for the purposes of this progress hearing, according to Mr. Shaper's testimony, I can find that the parents have been compliant since June 24th as it pertains to getting services set up and engaging. I can find, pursuant to Mr. Shaper's testimony, that the parents violated the safety plan on July the 3rd, 2024. And based on my previous order, I could order this case dismissed. And for a moment there that I was strongly leaning towards doing that. The only issue I have that is preventing me from doing so is not because I don't want to follow my order, because I do. I told you at the last hearing, Ms. Richardson, that you are very good at saying what you need to say when you need to say it. But there's always something else. And in this case, you set everything up, but then you and Mr. Mangold knowingly violated the safety plan. And it's just one more example of how there's always that one little thing. And if it wasn't for the fact that I don't want your baby in foster care, I would be dismissing this case right now and you'd be looking at a removal. But I don't want your baby in foster care. So I'm not going to dismiss the case today, but I'm going to make a couple extra orders that are going to be incorporated into this case. You are ordered to be in inpatient Thursday when you're supposed to be there. If you're not there on time, if you don't go, case is dismissed. No, it's just gone. It's dismissed. If you leave inpatient rehab at any point in time before they tell you you can go, this case is dismissed. Unless they tell you you can leave, you cannot leave. So if you check yourself out, then we're done. You're going to continue to do a meeting every day. So when you get to rehab, you find out where whatever it is that satisfies that. I know you're going to be an inpatient, but I made that order. I want you to follow it. So you sit down with somebody for an hour and you talk about your problems. You talk about your addictions, whatever it is, because that 90 days of you committing to that, to me, that is your first step in committing to something and not quitting it. So I don't care if you're in rehab, you're going to do 90 meetings in 90 days. You're going to continue to do that and figure out how to get it done. That's a commitment that I made you commit to, and you're going to stay with it. I'm not surprised that the hair follicles were positive. I expected that. I'm just disappointed that we couldn't follow a safety plan for 10 days. We couldn't even get to 10 days. So because of some of the other concerns that were brought to my attention and the fact that we couldn't follow the safety plan, and now we've lost a supervisor because of it, I'm going to order that Mr. Mangold not have any contact with the 2 children that aren't his until the kids are in therapy and he's addressed issues, but ultimately until further order of the court. So somebody's going to have to come to me in one of these meetings, these hearings, and say, the kids seem to be doing okay. Mr. Mangold is engaged. We think it's probably okay for him to have contact with the children again. Until that happens, there's no contact between Mr. Mangold and Colby and Nicholas. I'm only making these additional orders because I'm having mercy on you and not dismissing this case for your violation of the safety plan. And I'm only doing that because you've engaged, you've done a lot. I want to see you do more. And I want you to know, Miss Richardson, that as much as you may not think so, not only your attorney and Mr. Mangold's attorney, but this attorney ad litem on this case really wants to see you improve your life. And you need to be aware that as much as it seems like she's fighting against you, it's because she wants you to get help. And that's part of the reason why I'm making my decision today. Miss Rush, are there any questions about my order?
No, sir. Thank you.
Okay, that'll be the order of the court. We'll be back for our status hearing. I don't think it's very long, or sorry, compliance hearing August the 13th. So it's a month from now. I expect to see great things in a month from now. And if I hear before a month from now that something has gone awry, then we're just going to be dismissing and we won't need that hearing. Yes, Ms. Fuller?
I'm out of the country that day. We were going to ask Ms. Greenlee if she had another date.
Right, and she was out. So get with her and see if we can figure out another date, and then we'll put it in the order.
Thank you, sir.
You're welcome. All right, all parties are excused. Good luck to you, parents.
Thank you.
Thank you, Judge.
I see the attorneys in the breakout room just briefly, please. Mr. McKeska, would you please begin the announcements?
Yes, Judge Drake McKeska, attorney for the department.
Desiree Flores, FPS supervisor.
Matthew Schaefer, family-based caseworker.
Irene Acosta, attorney ad litem, appointed to represent the respondent father, Corey Mangold. Mr. Mangold, can you unmute and announce, please?
Corey Mangold, father of Doc.
Jennifer Harris, attorney for the respondent mother, Ms. Richardson. She's here. Ms. Richardson, can you please say your name?
Sarah Richardson, mother.
Deborah Fuller, attorney for the children, present already, Your Honor.
Right. We're here today for a compliance hearing on a TFF case. Mr. McKeska had mentioned in the breakout room that Ms. Rush, when she was still covering this county, had filed a motion to transition from TFF to court ordered services or required participation. Mr. McKeska, do you want to say anything on the record about that now?
Yes, Judge. My understanding would be that we'd have to essentially dismiss this case, file a new petition, right, and basically start over, because there's separate provisions of the family code that they get filed under. The contents of the affidavit are different. So my proposal is the department actually just waive that motion, Judge, and continue with the TFF case. The provisions that we filed under for TFF give us access to the evidence-based services, but those aren't the only services ordered on the family plan of service. If the evidence-based services aren't available in this case because of the parent's circumstances, then we can continue on with the other court orders for services without the evidence-based services being included in that petition. So essentially, the TFF petition gives us the keys to those services, but it's not the only service included in the order. And so this case can continue even though those services aren't being provided at this time.
All right. Any response to the department's position?
Your Honor, I just want to make sure that, if there are any TFF services that can be provided, that I'd like to, Ms. Tavini is with the TFF program, and maybe she can let us know if they're providing anything.
Well, let me make sure I'm on the right track here. Mr. McKeska, do you have any specific, I know you're taking this case over, do you have any specific information as far as what involvement we're going to have in this case between TFF and required participation as far as services go?
No, Judge, but I'd be able to call witnesses and flesh out that testimony.
Okay. Why don't we do that first? Ms. Tavini is here, but I don't know if you would prefer to call her or if you wanted to call either Mr. Schaefer or Ms. Flores.
Judge, I can call Ms. Tavini.
Okay. Ms. Tavini, did you take the oath?
No, sir, I forgot.
All right, that's okay. Would you state your name, please?
Michelle Tabini.
Do you swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Proceed, Mr. McCusker, please.
Thank you, Judge. Ms. Tavini, how are you currently employed?
I am the program coordinator with DePelchin, and we're subcontracted under the TFF with Belong.
Okay. And are there any TFF services being provided to either Mr. or Ms. Richardson or Mr. Mangold at this time?
For as far as the brief strategic family therapy, the evidence-based model through TFF, no, it is not being provided to the two parents.
Okay. Does the brief strategic family therapy model require Ms. Richardson to be present, or would you be able to offer that service to Mr. Mangold and the children in this case?
It does require the parent to be living in the home with the children, and because of the circumstances of Mr. Mangold and his paternity, like with the children that would qualify for brief strategic family therapy, it wouldn't be a good fit for them because the child, I believe, is not old enough.
Okay.
So that would need to be a different model.
Okay. And so the brief strategic family therapy then would be for Ms. Richardson as the biological parent to the oldest child. Is that correct?
Correct.
Okay. Pass the witness, Judge.
Ms. Harris?
Nothing, Your Honor.
Ms. Acosta?
Were any services able to be offered to either parents?
I know the intake wasn't ever done for brief strategic family therapy. I don't know if CPS or FBSS has provided any other services, but we did not.
Okay, thank you. I'll pass.
Ms. Fuller?
Ms. Tavini, can your agency provide assistance to Ms. Richardson once she is completed her inpatient?
It's possible. If she's residing back in the home with the children, then that's possible. But she would have to be living in the house with the children to receive the BSFT under TFF.
Thank you. Pass the witness.
Any other questions for Ms. Tavini?
No, Judge.
Right. Any other witnesses as far as this particular procedural issue is concerned?
No, Judge.
Okay.
No.
All right. Then Mr. Schaefer, as far as this case at this point in time, where do we stand? And are the parents in compliance? And are there any particular issues we need to address?
Your Honor, as of right now, I'd be happy to say that both parents are in compliance. I'm really proud that Ms. Richardson had entered in successfully into inpatient treatment, has been very proactive in her recovery and addressing the addiction. I've had nothing but good progress reports from her counselor and also speaking with Sarah as well. You can tell really about her way of thinking, her mindset, demeanor, her overall attitude has been in a positive manner. So she is very well prospering through on her end in her recovery, being there at inpatient treatment. She is actively engaging in NA and AA classes. They offer Monday through Friday daily. And then on the weekends, she's able to do NA and AA packets, which her counselor states that she actually is engaging in addition. So she really wants to meet that goal of 90 NAs in 90 days. There's been no negative reports in regards to her ability to be a parent and do the parent role and duties with Doc being in her care and treatment. Hasn't been any hindering involved in her treatment. So where she stands right now, she's doing quite well. The only thing that's lacking on her court order services would be her psychological evaluation. I was able to communicate with a secondary worker in Tom Green County to get that set up now where we have the ability to do it virtually. So that is the next step that I'll be working on, is getting that psychological set up so she'll be in compliance in that manner. Other than that, she's doing exactly what she needs to do. As we all know, the big test will be once she does complete 90 days, as she states that's her goal to reach. And we're looking about, I believe October 11th would be the 90-day, roughly, give or take a day or two, with her being discharged. So the big test would be when she's out, how things go and proceed on from there. But right now she's doing well. In regards to Mr. Mangold, he too has been in very much compliance. He's testing for us randomly and they're negative. He's engaging in his outpatient treatment with South Texas Rural Health. He's engaging in individual counseling with Ariana Hernandez at the same facility weekly. He did complete his psychological evaluation. The only thing lacking for him would just be his follow-up with his mental health appointments with MHTD in Hondo. Currently, that was put on hold as he did start employment, and he wanted to make sure he got something established to where he can then kind of figure out a plan as to what they're going to do with his availability. So other than that, with him, he's been in compliance. In regards to the no contact order, he's been following that as well. There were a couple instances where it appeared that it could have been broken. There was a scheduling issue in regards to the facility with the boys' schedule and dad's schedule, or Corey's schedule, where he did arrive and at the same time, but the kids were in the lobby, but he noticed and he just kept walking. Staff was able to corroborate that story that he did not look at them. He did not stop to talk to them or interact in any manner. He proceeded on to the back where he met with his counselor. And other things that rose up were the possible phone calls being made. Through further investigating, I was able to corroborate that due to certain setup of their phone plan and whatnot, it appeared as if Corey was calling the children, but in fact, he was not. It was actually Sarah. And again, I was able to corroborate that through trial and error and determine that when one parent would call, it would bring up and show up as the other parent. So it appeared as if he was trying to contact them, but he has been actually following the no contact order. So I want to make that known. So in regards to the parents, I can say they're really in full compliance with how things are going.
All right. Thank you, Mr. Schaefer. Mr. McCaskey, any questions for Mr. Schaefer?
No, Judge.
Ms. Harris?
Is there anything else that you're wanting from Ms. Richardson at this time?
Nope, just to engage in her psychological evaluation when we set it up.
That's all, Your Honor.
Ms. Acosta?
Yes, Your Honor, thank you. Mr. Schaefer, is the no contact order still necessary?
I've spoken to the therapist to get some recommendations and feedback, and she did not have anything, nor did the outpatient therapist have any safety concerns or worrisome concerns in regards to Mr. Mangold and having contact with the children. They just really wanted Mr. Mangold to focus on his continued efforts in self-care and working on himself, but there was nothing that was imperative to cause an issue of any type of safety concern to be around the boys.
Okay, and so do you think that it would be appropriate for him to be allowed around the boys at this time?
Based on the evidence and information I've obtained, I do not see an issue with that.
Okay, is there anything else that Mr. Mangold needs to do at this time?
Would just to engage in his follow-up on the recommendations of his psychological to engage and follow up with his mental health needs through MHTD and Hondo.
Thank you. I'll pass to the witness, Your Honor.
Ms. Fuller?
Mr. Schaefer, in regards to Ms. Richardson, how often is she able to see her children?
She's able to see pretty much weekly, depending on if her own maternal grandparents are able to get the boys up there and or if the department is able to assist. I know that the maternal grandmother did make an attempt and go up there with the children and have contact, and the department has also helped out as well with taking up the children. So ideally, she does have the capability of having weekly visits depending on the availability of who's transporting her.
How often is the department able to transport?
When I talked with upper management, we stated that it was ideally right now with availability of our transporter with other clientele that the department could offer at least once a month transport up there to San Angelo.
So is there a possibility that you could extend that to twice a month so these boys have an opportunity to see their younger brother and spend time with their mom?
Absolutely.
Okay. And what about telephone contact? How often does she get that?
I know that's been going on pretty much weekly, if not 2, maybe 3 times a week. I know that the phone conversations have been occurring and there's been nothing risen as a concern with the phone contact. So I know I've spoken to the boys and they've talked about, how their mom's doing, and that it's good to hear from them and see her as well.
And then for Mr. Mangold, in regards to any therapy he's receiving, are they addressing the anger management issues that were brought about in the police reports?
They're not totally in depth yet. They were still working on opening the realm of him focusing more on himself and self-care. I do know that talking to Mr. Mangold and the therapist, this was kind of a rough patch for him when when Miss Richardson did leave with Doc. The separation of them has made him feel a little bit depressed. And so the therapist and Mr. Mangold are working more of like, hey, self-care, working on things to help yourself and kind of get out of that feeling. So that's where they're at right now, is focusing on his self-care and his managing those coping skills and whatnot. But anger management is something that's going to be discussed further in depth.
And then what about family therapy for Ms. Richardson and the boys and for Mr. Mangold? and the boys?
Yeah, depending on what we were going to do about the brief strategic family therapy, if that was to end and step aside, then that's something very well the department would just carry on and take over once Ms. Richardson does exit successfully. Ariana Hernandez can continue in the family therapy, whether if the no contact order is set aside. Mr. Mangold can do that already with the boys if the court deems that that's appropriate. So yes, the department will carry on in that need.
Okay, and so do you feel comfortable that with Mr. Mangold attending family therapy with Ariana and the boys?
Absolutely. I don't see anything negative about that.
Okay, pass the witness, Your Honor. Oh, one other question. Is there any services or clothing or anything that CPS can provide to the grandparents to assist with boys since they've started school?
Yes, we do have a rainbow room that I do know that has some supplies and such. So I feel that we'll try to do our best to gather up some necessary school supplies. And then we'll look into the community and what Bexar County may also have in regards to clothing and whatnot to try to fulfill that need for the boys.
Okay, thank you. I'll pass the witness, Your Honor.
Any other questions or witnesses?
No, Judge.
Okay, Ms. Fuller, anything else you want to report?
I mean, the boys are doing really, really well. They're very happy. They're actually very talkative. When I saw them last week, and they miss their mom. They want to see her more. They say they only see her twice a month, and so they wish they could see her more. So if we can arrange that and assist in any way, I think that would be good for them and good for Miss Richardson. Plus, they miss their younger brother. But overall, they're doing really good. School is just starting. I was hoping that we could get some assistance with school clothes. They don't have uniforms this year, so it's more of a burden on the grandparents, and they can't really, Sarah can't really assist. She's in treatment and financially, and so I would just hope that they can see their mom more often, and then we could get some assistance for clothing, shoes, and stuff for school, and then to start family therapy with Mr. Mangold right now to see how that goes.
All right, thank you. Then for the court order compliance or the TFF compliance hearing, court finds that both parents are in compliance with their services in this case. It's in the best interest of the children to continue the court ordered services case. Our next hearing will be November 12th, 2024 at 1:30. November 12th, 2024 at 1:30. I'm going to order that the no contact order be abandoned at this time and order increased contact and visitation as possible. And I'm going to order the department to assist with clothes and whatever needs the boys might have as possible. I'm really proud of both of you for the progress that you've made since we were last here a little over a month ago. Sounds like things are going really well at this point in time. And just encourage you to continue. And I know you probably heard him say it, Miss Richardson, but you're doing great right now. When you get out, you got to keep it up. You get the tempo that you're at right now. It's got to stay where it is because that's the test, and you know that. And Mr. Mangold, you know that as well. So the best thing to do, and I'm proud of you for continuing the 90 meetings in 90 days. I'm glad that you took that seriously, Ms. Richardson, and that you committed to that. And I just hope that when you are released in October, because we're not going to be here until after that you continue what you're doing. It sounds from what Mr. Schaefer said and what Ms. Fuller is saying that you really are showing a genuine and authentic effort here, which is what we've wanted to see for a long time. And I'm just really encouraging you to keep it up because when you leave there, you're going to have lots of reasons to fall back into old habits. And I know you're learning these things, and I know you probably hear it all day, every day, and you're sick of it, but that's where we need to be right now. So I'm proud of you for what you've done so far, Mr. Mangold. I'm proud of you too. Keep up the good work. And I'll see you all November 12th at 1:30. Anything I failed to address?
Yeah, Your Honor, I just asked that the initial contact be through family therapy with Mr. Mangold. I don't think, I think we need to get some idea with the therapist to do a recommendation on how often. That these are not his children, but if he's going to be a part of the family, I think that the initial contact should be through the family therapy. The boys are enjoying therapy, and then that therapist could give the recommendation.
Yeah, I agree. Let's do the first visit through therapy. All right. Anything else? Okay. Thank you all for your time and your service. All parties are excused.
Thank you, Your Honor.
Thank you, Judge.
Thank you, Your Honor.
No objections.
Ms. Rush, would you please begin the announcements?
Versal Rush and Leslie Whiteley for the department ready.
Miss Wagner's also with the department.
Excuse me, Amber Wagner, Belong Adoption Specialist.
Laura Martinez, Adoption Supervisor.
Deborah Fuller, Attorney and Guardian ad litem for the children.
All right, this case started with 4 children, then it became 5 children, and now I think it's down to 3 children. Justice, Brooklyn, and Aiden.
Your Honor, Jeriel is involved, but he's a runaway.
Right. I don't have him in the report, and I've got him listed in my system that he's been on basically unapproved independent living since February, even longer than that.
Yeah. Yes, sir.
So I'm just going to keep him on that status. We don't know anything unless you've gotten some information, Ms. Wagner. I can ask you about it.
That would be Miss Whiteley.
Miss Whiteley. Okay, I'm sorry. Miss Whiteley, so Justice is, well, you're talking about Miss Whiteley for Jeriel.
For Jeriel and Julius, which I think we were dismissing. Julius.
Yeah, I've already signed the order to put Julius in extended foster care. I signed it the other day.
Yeah.
Okay, so let's stick with Miss Wagner for now. Justice is 12, Brooklyn's 9, Aiden is 5. Aiden and Brooklyn are still in a foster home in Harris County, correct?
Yes, Your Honor.
And then Justice is still in the group foster home in Gonzales County.
Yes, Your Honor.
Are those placements safe and appropriate, meeting their needs?
Yes, Your Honor.
Are the placements in their best interests for them to remain there?
Currently, yes.
Okay, and the permanency goal for Justice is still adoption?
Yes, Your Honor.
And same for Brooklyn and Aiden, except their potential adoptive parents of the foster home?
No, Your Honor. The potential adopted, we're doing an ICPC to Hawaii with their older sibling, with their older sister.
That's right. Yes, I completely blanked on that. And that ICPC is still in progress, correct?
Hers was done 5/30 and accepted on 5/31, so they'll be starting that progress. Aiden's was not done until July 3rd. I did not attach him to Brooklyn's, and so it was done on July 3rd. And as of this morning, I'm still waiting for the approval at the state level.
Okay. I did see one thing in the report about that ICPC. The sister's name is Alicia Torres, correct?
Yes, sir.
Okay. Because in the report, and this just kind of threw me off, and I figured it was just a typo, under Justice's section, it says Gidget Torres, but that's a mistake. She's not involved in this in any way, correct?
No, that should have probably said Georgette.
Georgette.
Yes.
Okay.
Yes. The maternal aunt's name is Gidget. I'm sorry, it's Georgette. Mom is Gidget.
Right.
I apologize.
No, it's okay. I just wanted to make sure I wasn't missing something. Just double checking it. Okay, and so you believe that their placement right now is safe and appropriate, meeting their needs, but based on this ICPC, there's going to be a potential move.
Yes, sir.
All right. Now we did this a year and a half ago, maybe 2 years ago, and things didn't work out so well. So what are we doing differently this time that's going to make this more of a sure thing?
Justice is going to the one family. They're only taking Justice because they don't have space. They have 3 kids and they have 2 bedrooms, and so they'll have to share, and that's why they can't take the other kids. So I think just by fact that only Justice is going to be going to that home, I think that one will be successful and completed pretty quickly. The other 2, I honestly don't know. She doesn't have stable housing, and so I don't know exactly how it's going to go in the future with her.
But all those are in progress.
Yes,
and
sir.
one of them's done.
Justice is done. Mostly we are waiting for them to finish some paperwork. They need their car documents, and they're waiting on a character reference for Mr. Vega. And that was as of last night.
Okay. All the children are up to date on their medical, dental, and vision?
Yes.
All right. And I'm just trying to remember here and look at this report, refresh my memory. Aiden was, at the last hearing, Aiden was the only one on psychotropics. Is that still the case?
He is on allergy meds, and he has diazepam for seizures, but only as needed. He had been taken off the Keppra back in January.
Okay. Nobody else is on anything that I could see?
No, sir.
Okay. How are their behaviors?
Justice is a pretty chill kid. You know, he's easygoing. He's working through things through therapy as he's meeting them. Brooklyn does struggle in school with her behaviors, throwing tantrums, and she also does the same at home. And Aiden is just, you know, he's 5. He's hyperactive. He's all over the place. He's pretty easy to redirect. I don't get a whole lot of reports on them that anything is going on.
Okay. Everybody's educational needs being met at this time?
Yes, Your Honor. We are planning a 50, I'm sorry, not a 504. I did send an email to our education specialist for Brooklyn this morning to see about getting her scheduled for special education testing. They had been done before, but she didn't qualify. But I believe that there are some things that that need to be readdressed and maybe looked at a little bit further just due to her behaviors that are impacting her education.
Okay. And I'm assuming the visit to Hawaii went well. I didn't hear anything negative. So
the visit went to Hawaii, went well. Unfortunately, Justice did show up, come back. He came back sick.
Yeah.
But other than that, it was, you know, no injuries. They had a great time. The family was great.
Okay. All right, let's talk about Jarrell. Ms. Whiteley, what's going on with him? Last time we were here, he was in unapproved independent living, and there had been some talk about him potentially going to. Oh no, that was Julius. He's out. So where are we at with Jarrell right now?
So at the last hearing, you had approved Jarrell to be in his own placement. He was at the time living in a small 1-bedroom, like a mother-in-law suite off of somebody else's backyard.
Mm-hmm.
So when I left court, I went to go find him and he was no longer at that location. We became aware that he is with his mother. He is staying with Gidget Torres in San Antonio. I was able to visit with him about 10 times, trying to get him to come back into care with us. However, they have since been evicted and we cannot find Jarrell. We have a special investigator looking for him. He's been posted on NCMEC. We're just unable to locate him. The special investigator was in communication with Gidget Torres, and she had reported that Jarrell was with her, but she would not allow Jarrell to talk to the special investigator.
Okay. So that's about the gist of what we know at this time.
Yes, I do know and feel confident in saying Jarrell is talking to Julius, and Julius reports Jarrell is doing good.
Okay. Any further orders that you're requesting as far as Jarrell goes?
Not at this time, Your Honor.
Okay. Ms. Rush, questions for Ms. Wagner first?
Yes. Am I correct that Hawaii requires any ICPC placement to be licensed as a foster home before they'll actually accept the placement?
Yes, ma'am.
And the potential placement for Justice is well on their way to being licensed, correct?
Yes, ma'am.
Am I also correct that once they're licensed, there's no requirement for 6 months, 3 months, whatever, for licensing before Justice can be placed?
Yes, ma'am.
Okay. Regarding Aiden and Brooklyn, frankly, you're asking for an ICPC for Hawaii for the adult sibling, but we're not really confident Hawaii is going to accept it. Is that fair?
Yes.
Have you attempted through the potential adoptive home for Justice to seek out any other person in Hawaii, including people who know the Justice's placement potential, who might be willing to take these other children?
The only person was Alicia. There was one other person that stepped up, but unfortunately her housing situation she didn't have enough space in her home to allow a child in there. And the other family members that I met with there have not said anything.
They don't even have friends who are available.
They haven't given me any information on any other friend or family member other than who I met and that young lady that I spoke with.
And my last question is, if Hawaii turns down the ICP for any reason, including that they don't like the color of the bedroom, we have no say on that, correct?
Yes, ma'am.
Pass the witness.
Fuller.
In regards to the trip to Hawaii, did you meet with other relatives?
Yes, ma'am. I met with multiple relatives at a birthday party with the kids.
But you did not discuss this case with them, did you?
I did. I discussed it with several of them, asking them about, their plans, how they felt about the kids.
So when you sent me information that you didn't feel that the birthday party was a place to discuss this, that's not true then?
Well, when I got out there, I realized that there was a lot going on and that I could speak with each individual family member and it wouldn't be I had time that I could get them away and speak with them briefly to see what their thoughts were. I was expecting a very large, raucous birthday party where everybody was involved, but a lot of people, they were down at the beach and they were playing, so I had that opportunity.
When you were in Hawaii, did you even go to Miss Vega's house?
No, ma'am, I did not. I was sick
So
and
you
I was
were
unable to get out there.
So how long were you in Hawaii?
I want to say 5 or 6 days. I don't remember the exact length of the trip.
And when you came back, you didn't have the name of anybody that could be looked at. You didn't even have Charlotte Rivera's name, did you?
No, ma'am. They gave me that information after I came back.
Okay. So in regards to the whole point of going to Hawaii was to try to find relatives for these children, these 2 younger children, correct?
Correct.
Bring them there and try to see who you could talk to.
Yes, ma'am.
But that wasn't done, was it?
No, ma'am. I did speak with multiple family members while I was at that birthday party and asked them. I asked the family and I asked them if they knew any family members or friends. I asked
Who did you
Vegas
speak to? Who did you speak to, Ms. Wagner?
Oh gosh, I don't remember their names right off the top of my head.
Yeah. Okay.
That's
In
been a
regards to
long
the
time.
ICPC, when we were in court in February before this case became yours, the ICPC was supposed to be done for justice, correct?
Correct.
And did you follow up and make sure everything was correct?
Back when I got the case, I was unaware that the previous ICPC had been started, so I started a new one. Hawaii has been working with the prior ICPC that was started by Lorna back in December. So they've been working all this time using that original ICPC. The one I submitted was an error, so they haven't been using that one.
So in regards to Brooklyn and Aiden, when you went to Hawaii in March, it was determined that Alicia wanted to be steady, correct?
Correct.
So how come your testimony was you didn't do the ICPC till May 30th or 31st? I don't even know which day. You were there in March. And so 2.5 months later, you decided to turn in the ICPC.
That is 100% on me. That is my error. It did get overlooked and it was just on my to-do list that kept getting moved down. That is 100% on me and I will own that.
And even with Aiden, once Ms. Rivera, which was pretty soon after you came back in March, when we determined that she wasn't able to even be a placement, and Alicia said she would take both if possible, you didn't turn in Aiden's until July 3rd.
You're correct. I did not add him to Brooklyn's inadvertently, and that again is my fault, and I apologize for that.
And in regards to the February order, where these children were supposed to have continued contact, a consistent contact, did you ever set up any contact or work with Miss Whiteley to set up contact with Julius and the kids on your caseload?
We had visits scheduled. Yes. We also had our mobile case aide out of Houston that was canceling like a day before last minute for visits. I was unable to find people to pick them up the next day.
So how many times since February have these children actually been able to communicate with each other and see each other?
I took them for a visit on the 15th of last month. I do not know if they've had any other in-person visits.
So when the court says the sibling communication needs to occur, hold on one second, as much as possible. So one time since February that you know of, that you did?
And like I said, there were multiple attempts for a visit, but our transporter would cancel. And unfortunately, finding somebody a day before to transport 4 kids, all over Texas, it can be difficult because schedules are already set.
And in regards to the telephone communication, what kind of communication have they been able to have through the telephone contact?
The Miss Washington, where Brooklyn and Aiden have been on the call list, but they have not been calling. I was unaware of that. Also, I had provided them the information for the family in Hawaii at Justice's placement, and then found out that they only will do phone visits Monday through Friday, 8 to 5. We just found that out about a week ago. They do not facilitate phone visits on weekends or evenings. And so that hasn't been being done, but I have scheduled visits every Saturday for the next, I think, 8 weeks for me or another belong staff to go out to Legacy Ranch and make the phone call with him to Hawaii and to the kids in Houston.
So basically, Justice has not had any communication until this past weekend when I facilitated communication with Ms. Vega, who's supposed to be his placement and his adoptive parent, since you went to Hawaii.
Correct.
And Brooklyn and Aiden have not had consistent contact with Justice since you went to Hawaii.
Again, like I said, they have been on the call list and I was unaware that they weren't calling. I don't know if their situation there is, I want to call, so they have to ask to call, or if they set them up. But if I'm getting clarification, and if need be, I will have them set up a
But the
schedule
court-
to make phone calls.
The court order says that you're supposed to have as much communication as possible. So that's belong. That's supposed to ensure that these children have communication, see each other. Even policy is that they should be seeing each other at least once a month. And so why is this not occurring?
Again, like I said, we did have visits scheduled. When the transporter cancels last minute, trying to find somebody that can make that move is sometimes difficult. So yes, there were visits scheduled that were canceled and due to weather. There was one canceled that was due to weather last month. It's not for a lack of trying. It's, having the people available to do it.
But for the phone calls, you didn't even know they weren't happening. So
you're correct.
You have to meet with your children and staff your case once a month and meet with the children. How did you not know? I mean, that's the first thing I heard from Justice. I don't get to talk to my siblings. When I saw Justice the last time, he was with the kids, with the brothers and sisters. So, and when it came to talking, he never even asked me about talking to people in Hawaii. He just asked me how it was going. I told him it was still in the works and I didn't have an answer. But it's not up to an 11-year-old child, 12-year-old child to say, why aren't you doing this?
I'm just saying that the phone calls, I was unaware he didn't mention. So I thought, okay, these are going on. You are correct. That is my assumption and that is my incorrect self. And I apologize.
What is going to be done now to make sure that these children get to see each other, get to have contact with their possible placements, and ensure that, they can be a family?
Like I said, I have scheduled time on Saturday for the next 8 weeks where me or somebody from Belong will go to Legacy Ranch and call Hawaii with Justice at 2:00 in the afternoon, and then allow him to call Brooklyn and Aiden in Houston. We are working on scheduling a visit for the kids in the next 2 weeks. I'm just trying to get transportation figured out.
But if we didn't have court today, none of this would have happened. Nothing's happened since February. So now that we're having court, we're going to get on this, correct?
You're correct. Yes. Like I said, anything that has not been done.
I'll pass the witness, Your Honor.
Back to you, Ms. Rush.
I want to make sure I understand something. Julius, who's now in independent living, right?
That's
Julius,
Leslie's
yes.
kiddo.
Yes.
No, but Amber, that's who Julius is, right? He's the older child.
Yes.
Okay. And am I correct in my understanding that he gets to see the siblings, including Justice, whenever he wants?
Correct. I did take him to the last visit.
Okay. So I understand Belong has not followed policy in allowing and setting up visits between Justice and Brooklyn and Aiden, but Justice has been having visits with Julius.
The only visit I am aware that Julius has had with Justice was the last visit that I took them to. I don't know about before that. I don't think so.
Would Leslie have a better answer to that?
He should.
Okay, pass the witness.
Any other questions for Ms. Wagner?
No.
All right. Ms. Rush, did you want to ask Ms. Whiteley some questions?
Please. Thank you, Your Honor. May it please the court. Leslie, are you aware of Julius's visits with the siblings?
Yes, ma'am.
Okay, could you tell the court 1, 2, 3, ever how many he's visiting and where and when and how that happens?
Julius has visited with all 3 of his siblings once a month since I took over the case in February. He gets taken to Legacy Ranch to see the siblings, as well as Julius had a special visit, I want to say 3 days prior to Justice's birthday. He was taken to Legacy Ranch so that he could spend time with Justice, as well as Justice and Julius are able to talk on the phone. So anytime Julius calls up there, they will let him know when he can call back to speak with Justice.
That's all, Your Honor. Pass the witness.
Ms. Whiteley, do you feel that even though CPS or Belong is going to be out of Julius's case, that the placement will continue to allow him to have contact?
Yes, ma'am.
And he was in that placement prior to graduating from high school?
Yes, ma'am.
And do you feel all his needs have been met during this time period and now into the extended jurisdiction?
Yes, ma'am.
Okay. No questions, Your Honor.
Anything else from the department?
No, ma'am. No, sir. I'm sorry.
All right. Ms. Fuller?
Obviously, Your Honor, again, another disappointment with this case. Julius, he's been able to have contact. He has his own cell phone. He's been doing really well. He did not go to school, but he is working full time. He has his apartment and, he's been able to see his siblings. In regards to Jarrell, I've attempted, I don't know how many times to speak with him. He refuses to speak with me. I haven't been out there looking for him. I will let the court know. I've texted him. I've called him. I've had Julius try to tell him to speak to me because I was hoping he could come back into care for one day just so he could qualify for, free college and everything, but he won't even speak to me. So I don't know what else I can do for Jarrell. In regards to the 3 younger children, complete disappointment in the way this is being handled. We talked about ICPC last year. It was supposed to be done in November, never got done until January for Miss Vega. It's not her fault that she can only take 1 child. There's a restriction that you can have 2 children in a room. She has 3 children. That was somehow, I don't know if it was mishandled in January, but then it was attempted again in March, and that was a big fiasco. When Miss Wagner went to Hawaii, obviously we were all hoping that she would have conversations with people and try to find someone to place the children with. That didn't happen. She didn't even go to Miss Vega's home. She went to a party for less than 2 hours and never saw the children again. For the 5 or 6 days, Miss Vega picked them up from the airport and she took them back to the airport. There was no attempt. That was just for her to even meet with people. That was the point of this. And then we find out, yes, Alicia really wants to do this in March. And now we have ICPC turned in May 30th and then July 3rd. We are supposed to be trying to get these children back to Hawaii. They are Pacific Islanders. They need to be with their family. I don't see that any urgency on the part of the adoption worker in this case. I'm concerned that it's been mishandled, that the ICPC hasn't been, I don't even know if it's been done properly now. To be honest, I've asked for months to show me when it was turned in, to give me updates, nothing until yesterday, And so I'm really frustrated that these children are not going to be placed in Hawaii because of Belong not doing their job. Hopefully Miss Vega has done pretty much everything on hers and justice can get there. School starts at the beginning of August there. He wants to go yesterday. He's so excited. He wasn't even allowed to talk to her since March. And this is going to be his adoptive parents. I mean, there's no excuse for that to say, oh, I just found out they weren't talking. You see children every month. It's required. And then you don't follow up on them having connections with their placement. I mean, my understanding, Brooklyn has been talking to her sister. Miss Washington has, facilitated that. So that's a good thing. But Justice, who should be going as soon as possible, doesn't even get to talk to his aunt and uncle. So I don't know what can be done, but this is totally frustrating that these children and their case has not been handled properly. And I don't know how many times I have to ask for things. And, again, the court report was filed at 5:30 yesterday. I could have, objected to us even having a hearing, but, I'm very frustrated. I don't know what the court can do, but something needs to be done. I think Ms. Whiteley has done her job. She's attempted. She's, really worked hard to try to get Jarrell where he needs to be. And she works hard with Julius. He has chosen, not to go to college right now, but he is working and he's doing okay. But these other children, it's not being handled properly, Your Honor. It's just not.
Thank you, Ms. Fuller. All right, I'll address this. Let me get my findings entered as far as the permanency review after final order. Court makes the finding that Julius is in extended foster care. I've already signed that order, and he's working and has an apartment, visiting with his siblings as he can. Court finds that Jarrell is essentially still on runaway. I'm not sure where he is. I'm not sure who he's with, and I'll make a finding that Miss Fuller has made attempts, and Miss Whiteley has also made attempts, and Jarrell is not being very cooperative. Permanency goal for the other 3 is adoption with their respective ICPC homes in Hawaii. Court finds those permanency goals are appropriate in the best interest of the children. Court finds they're all up to date on their medical, dental, and vision checkups, except for Jarrell. It's unknown as to him. Court finds that none of the children at this time are receiving psychotropic medication. The children have had an opportunity to express their wants and desires, and it's clear they all want to be adopted and be in Hawaii. And the current placements that they're in are safe and appropriate, meeting their needs, and they're the least restricted placements possible. However, court finds that it's in the best interest of the children to continue working towards the placements through the ICPC in Hawaii. Because of some of the concerns I've heard here today, I'm going to order the parties to staff this case within 7 days regarding a plan to move forward and meet the court's deadlines. And then we're going to come back for a progress hearing next month so that we can look at where we are. I want to know, and I want you to submit your action plan to the court when it's done within 7 days. And I want deadlines. I want dates on there. This thing is going to be done by this date for this child with this placement. I want to know what's been accomplished. And then we're going to come back in August and see where we are then too. So it's going to be August the 20th at 10:30. That'll be our progress hearing. Our next permanency review won't be until December the 10th, 2024 at 10 a.m. December 10th, 2024 at 10 a.m. But to be clear, all the parties, that means Miss Whiteley, Miss Wagner, Miss Fuller, and Miss Rush, and whoever else needs to be involved, you have staffing. And I just want it to be a constructive staffing on what needs to be done for this child. How do we need to do it? How soon can we get it done? Here's the date that we're shooting for. On everyone, all three. If there's differences in the placements, then you have specific action plans for those placements. We all understand that no matter how much work goes into this, Hawaii can decide at any point to say no. So it's got to be perfect, or as close to perfect as we can get it. So if everybody's on the same page and everybody has the same action plan, then everybody can hold each other accountable. I'm going to have it too. I'm going to have it within 7 days. It's going to come to my coordinator, and then she's going to send it to me. And then we're all going to talk about where we are on that action plan on August the 20th. Ms. Rush, anything further that I failed to address?
Just to let the court know, there's a good chance it will not be me in the meeting representing legal, but somebody from legal will be there.
If you could just make sure that they have a very distinct understanding of what I expect, that would be fine.
Your Honor, I take notes on Rocketbook and upload them to the server after every hearing.
All right.
And
Ms. Fuller?
Just to be fair, Miss Whiteley really wouldn't need to be a part of it. It's about the three younger children. I mean, unfortunately, we can't get Jarrell to do anything, and the department's dismissed from Julius. But
well,
again,
the
I
only
do
reason
appreciate
I
the work
said
she's
Miss
done.
Whiteley's name is because I didn't want her to feel excluded. If she doesn't need to be part of it, then that's one less person we have in the works. So that's fine.
She's worked really hard on the two kids that she took on. I feel confident that she's tried to, get Jarrell where he needed to be and has helped Julius.
Okay, that's fine with me then. All right, that'll be the order of the court.
Thank you, sir. Everybody have a good night.
For today.
Thank you, Your Honor.
Great, McCusker, attorney for the department.
Christy Canal, permanency supervisor with Belong.
Wagner, adoption specialist, Belong.
Deborah Fuller, attorney and guardian ad litem for the children.
Reviewed the report on the progress hearing. Obviously, we're here for a progress hearing, so we're not going to go through everything that's in it. I just mainly wanted to come back today. My order was have you all staff within 7 days regarding moving forward with deadlines, and then coming back today to see where things are. I did review the report, so my understanding is that the home study for justice is still moving forward. There's additional questions that need to be answered, and that is in progress. The home study on Miss Alicia Torres was denied, and that is no longer a viable option for the other three children. Is that correct, Ms. Wagner?
Correct. Alicia can, if she is able to provide like proof of income, housing, and fix the stuff that she stated incorrectly and all that during her home study.
Okay. The way it was worded in your report, it looked like she was consistently dishonest. Is that
she was, but I talked to Catholic Charities and they said that if she was able to correct those things, that they would reconsider doing that. They would reconsider it. I don't know if that means they would do it because the paperwork was there or what. They wouldn't give me a firm answer.
Do we want to continue to work with her with these children if we have questions of credibility?
That was my concern. My concern was that she was consistently telling people different stories.
'Cause
She
that would
told
be a
me,
concern for me too.
she told me one thing, and that she, and then she told obviously the home study people vastly different information multiple different times.
Okay. And then, I mean, that the main thing, did you all staff within 7 days? I mean, some of that might be moot now, but did you get that done?
Yes, sir. We did the staffing on, I do not remember the exact date we did that staffing. Oh gosh. That is the one thing I did not write down, was when we did that staffing.
And maybe I'm just out of the loop, but I'm trying to figure out exactly what y'all are talking about in regards to dishonesty. I mean, I was told she didn't have employment. I was told she was looking for housing. I think the biggest issue for me was that she actually is getting married and moved on base with her fiance. That was the one thing I was not told about. So I think they want to pursue it once they get married, and they want to go back and pursue placement of the two youngest, Brooklyn and Aiden. But is there something I'm missing, I guess?
Well, it says in the report, and I'm reading the report that everybody already has. I'm not reading anything that nobody else has access to. There was an ICPC pending for Alicia Torres, the older sisters of the children, per the ICPC denial from Catholic Charities Hawaii. Throughout the home study process, Ms. Torres provided their office with inconsistent information regarding her current relationship status, living situation, and future plans. During each conversation, Ms. Torres presented different information and admitted to lying to their office about her relationship status. That's what I'm referencing.
Yeah, and that's, I mean, that was the main issue that I had, was that I wasn't told until recently about her relation. And she told me, you know, about it, that she was engaged and that she moved on base, and that's why they had to stop the home study. But as far as not looking at her again, that's their sister. I think that she probably was intimidated by the process. She's young, and I feel that maybe she understands it better now. And she is getting, like I said, getting married in November to a young man in the military. And I think she was concerned that that was going to be an issue. It is an issue, and she should have just told everyone. But
well, I agree with you from the standpoint of, if she's young, intimidated, okay. But this whole family has had it. I mean, this is not the first time we've tried to do something in Hawaii and it failed. And this was not the first case where we tried to do something here in Texas and we couldn't reunify. So I want to be very careful moving forward regarding any time and effort and resources that are put into this family, because I just feel so sorry for these children. And I know you all do too, but I mean, they have had their hopes up and dashed and up and dashed repeatedly. And I just can't even imagine what sort of mental anguish and trauma they're dealing with that they might not even be aware of at this point because of all the disappointment. So I want to be very clear that moving forward, whoever we work with, at the first sight of any impropriety or dishonesty or inability to provide these children with a safe, stable, violence, and drug-free home, we move on. Because I just don't, on my watch, I don't want to see them disappointed again. If we can work with Ms. Torres in the future, we can find some way to salvage this, and it's a very tight ship, then okay, I'm willing to put time into that because she is family. But right now, I'm just very disheartened by this whole situation. Our next permanency hearing is going to be December the 10th at 10 a.m. December 10th at 10 a.m. Do we need any additional orders at this time between now and then that you're aware of, Mr. McKesker or Ms. Fuller?
I want to know what the status of Justice is, ICPC. They should be done. That one should be ready to go. He needs to get to Hawaii with his aunt, you know, because they worked really hard to get their stuff done, and that's where he wants to be.
Yeah, Ms. Wagner, your report does state that at the time you filed it, that there was some information needed. It may take a few weeks. Have you gotten an update?
They, excuse me, they did receive party information. They are waiting on reference information for Mr. Vega. That's the last thing they're waiting for. We've been waiting a week and a half or 2 weeks for them to get that done. I sent an email yesterday to see this week's updates, but that was last week's update.
Anything else on that, Ms. Torres? Or excuse me, Ms. Fuller?
No, just I mean, it sounds like the children are finally having pretty consistent contact, and Justice is able to talk to his aunt and uncle and his cousins. on a consistent basis. And I think that they're having contact within, with Brooklyn, Aiden, and Justice as well. I think that's improved.
And I think this might go without saying, but I want to make sure I'm not making any assumptions. With this ICPC being denied and there not being any guarantees that the other 3 children are going to be in Hawaii, does that deter Justice at all? Is it still full bore?
Not a bit.
Okay.
And I actually I saw the kids Saturday. I did a visit with them, picked up Justice, and we went to Houston and saw the kids. And I asked Brooklyn, and I was like, honey, what happens if Alicia is a no? I didn't want to come out and tell her that Alicia was a no right then. And I said, would you want to go to Hawaii? Where would you want to go? And she said, I don't really care if I go to Hawaii. And I was like, you don't want to go and be close to your family? I was like, if we could get you like on the same island or anything like that. She said, no. And so I don't know, up until this point, she was so excited, but, telling her that the Alicia thing might be a no, I guess kind of just killed it.
Well, yeah. And that's what I was getting at earlier is I think these kids have gotten used to disappointment. And that's just sad to me. But it is what it is at this point in time. Any other orders that we need?
No.
Okay, then I'll see you all back December 10th, 2024 at 10 a.m. Thank you all for your time and your service. If nothing further, all parties are excused.
Thank you, Judge.